Good morning, everyone. My name is Adam Rennett. I'm the IP Law Fellow at the Center for Intellectual Property, Information, and Privacy Law at UIC School of Law. During this event, I will be introducing each segment and providing details on event logistics. There's about 6 things I want to go over real quick, so bear with me before we get started. The first is you can access all the seminar materials 2 different ways. First, when we're in the table mode we were just in, you can access seminar materials by clicking the blue button that's actually at the top left of your screen that says Seminar Materials. You can also access them in the link that I posted to the general chat. The seminar materials contains basically written materials that we've prepared for this seminar, as well as slides for at least one of our panels. The second thing is we'll be dedicating up to 1/3 of any panel's time to attendee Q&A. So if you have questions, please use the Q&A tab off to the right-hand side of your screen. If the questions are in chat, it is likely that they will be missed, so please make sure to post them into the Q&A tab. During these panels, we're also giving moderators the option to invite 1 or 2 attendees actually up on stage so that they can ask their questions and perhaps participate in the discussion. Again, this is the moderators at the moderator's discretion. But if you want to ask a question, again, posting it in the Q&A tab can signal your interest. Also, you can raise your virtual hand, and which will signal that you would like to join the stage. Third, if you want to know what the center has been up to and what we've got planned for the future, we have our spring 2021 newsletter. Again, in the table mode, you can access the newsletter by clicking the blue button and following the links that is at the top right of the screen. You can also, as well as the program materials, I posted a link to the newsletter in the general chat. Fourth, I'd like to thank the student ambassadors that we have helping us this morning and throughout the day. They are here at the help desk, and you know who they are if you scroll through the participants. They have student ambassador in parentheses next to their names. They will be manning the help desk. They'll be sort of roving tech support. So if you have any issues or have any questions, please feel free to reach out to one of them. So a special thank you to Audrey Meyer, Natalie Lazaroff, Eric Moss, Jenny Armstrong, Matthew Kane, and Madeline Yark for assisting us today. A big part of these events is the opportunity to mingle, and being a smaller event, it's even more highly valued. So this is not Zoom. We have a couple breaks throughout the day. Please feel free to go move from table to table and speak with attendees or even speakers should they decide to stick around for the day. And then finally, if you're staying with us for the entire day, or even for the afternoon sessions, we are transitioning from this room to a second room around 11:35 a.m. Central, and that'll be after our session with Judge Jordan. I will prompt you and I will provide instructions at the time, but just to sort of give you a heads up, what we'll be doing is there is a link at the bottom right of the screen, a button that says click here for room 2. When prompted, please click that link and follow the link to room 2. Our student ambassadors, who I introduced before, will be on hand to help you with any issues. Without further ado, I'd like to bring Professor Daryl Lim up to the stage. He is the director of the IP Center.
Well, thanks so much, Adam, and good morning, good afternoon, good evening from wherever you are. Welcome to our virtual room here at UIC John Marshall Law School. It is a pleasure and a privilege to be able to welcome and host you for the second event that we have this year. This is our masterclass, and we called it a masterclass because we mean it to be an interactive, more intimate type of setting where you can actually engage more meaningfully with the speakers that we will have today. The theme of many of our events this year are intersections, and our first event focused really on copyrights, trademarks, design. Talks about patent specific patents in 4 different forums. the district courts, the ITC, the PTAB, and the Federal Circuit. And to guide us through those discussions, we have a really distinguished group of speakers, including present and former judges, one of which who is on the call on the screen with us right now, Judge Essex. And I'll briefly introduce them in just a moment. But before I do that, I just want to also thank our sponsors. You see who they are in the chat. Of course, our speakers and all of you, the attendees who are here today. Adam also mentioned student ambassadors. Thank you for joining us today. And of course, Adam himself, sometimes those who work hard behind the scenes are least appreciated. Now, the reason why Ken and Judge Essex, Ken Adamo and Judge Essex are here on the call with me in the introduction is because they're both serving as advisory board members and both been terrific in just helping me put together this session, suggesting speakers and topics. So I want to invite both of them to say a few words before we get into the first session today. I wish you all a good discussion, good learning, and have fun. So without further ado, Judge Essex, Ken, over to you.
Thank you very much, Daryl, and I want to thank you and the school for having me. It's an honor to be on these panels, and I am very grateful because I probably learn far more than I give out knowledge, and so it helps me and it helps, I think, the profession in its entirety. I appreciate it, and it's a pleasure working with you, and we've got a lot of fine people on the advisory board. Ken welcomed me there. He's been there longer, and he's certainly probably given you even better advice. So I'll defer to Ken, who I've known for a long time, and I appreciate everything he's done in front of me and everything he's given me, including his friendship. So Ken?
Well, thank you. It's a very exciting time to be at what once was the John Marshall Law School and now is UIC JMLS. John Marshall is now a proud member of the University of Illinois higher learning institution. The institution now has two law schools, one in Champaign-Urbana and now the second one in Chicago. I'm an LLM graduate of the program at John Marshall, God, back in the 70s when I still had some vestige of hair. And I've been lucky. I've grown up in the school and been shared and helped with a variety of different things over the years. We've got an amazing group of people who you're about to start listening to, with very timely topics and subjects. Everybody has done hours and hours of extra work to prepare, and we're all excited chomping at the bit to start talking. So with that, I think Adam is ready to bring the PTAB board online, and I will see you all again at the district court board in at 9:30 this morning. So enjoy, and thank you for being with us.
All right, as Ken said, we will get started with, so thank you for the introductions, all of you. I will be now switching out the individuals on stage. Let me pull up here. All right, so once these panelists come filtering in here, I would like to introduce the first panel. First panel is, as Ken said, is the Patent Trial and Appeal Board Practice panel. Let's see. We have our moderator, Brent Babcock. Good morning, Brent. Brent is a partner and registered patent attorney at Womble Bond Dickinson US LLP. As a reminder to all the moderators, all the ones who are here and listening, if you wish to introduce your panelists, please keep it short, names, affiliations, that's fine. If attendees want to, and to attendees, if you want to read any more, their speaker bios are in the seminar materials that I pointed out before. We would like to open up questions about an hour into the session. With that said, Brent, go ahead and get us started.
All right. Well, thanks very much, Adam, and good morning, everyone. And for those of you maybe in other time zones, good afternoon. Really excited to talk about some of the recent developments in the Patent Trial and Appeal Board. We've got a great panel, and we're going to start obviously with our most prominent panelist, Judge Jackie Bonilla. She is the Deputy Chief Administrative Patent Judge at the PTAB. So she's on our panel to give us some perspective from the PTAB. We have Herb Hart, who is a shareholder at McAndrews in Chicago. Lori Gordon, a partner with King & Spalding in their DC office, and Leslie Kitten, who is at Stern Kessler, also in DC. I do want to emphasize that we would like to make this as interactive as possible. So feel free during our discussion to ask questions through the Q&A, as Adam mentioned. We will try to answer those questions throughout the session. We will reserve some time at the end for us to be able to dedicate to Q&A, but sometimes it's helpful to have the questions answered real time. So feel free to post those questions, and Adam and I will try to get those posted to the panelists as we proceed. So we're going to start this morning with a very hot topic in the Patent Trial and Appeal Board, and that's discretionary denials. And we have seen a dramatic shift, at least in my perspective, dramatic shift in how the PTAB practice has evolved in the last year or so, particularly with how the board is handling denials of petitions based on discretionary factors. The one that's received most comment and the most controversial is the NHK Fintiv factors, which are discretionary denial analyses the board does based upon co-pending parallel litigation. There's also some more historical issues in discretionary denials is involve parallel petitions. When petitions are being filed simultaneously, the board's trial practice guide handles some of that. We have serial petitions when you have a sequential filing of petitions directed to the same patent. The board handles that through a series of factors, the general plastic factors. So that's also an area that's been somewhat controversial. 325D, which allows the board to deny petitions based upon prior art that's previously been considered by the Patent Office, as well as the SAS Institute case, which allows the board to look at how many grounds that are being presented in a petition that may not be meritorious and potentially deny petitions based on the lack of the plethora of non-meritorious grounds. So with that background, I'd like to turn it over to Lori and kind of get a petitioner's perspective on how this evolution in discretionary denials has changed the practice.
Okay, thanks, Brent. And from the petitioner's practice, this has been probably one of the most dramatic changes and evolutions at the PTAB since the first petitions were filed in 2012. I want to start with the Fintiv denials, which if you are a defendant in one of the rocket dockets, like the Western District of Texas, and I think the majority of defendants these days find themselves in Western District of Texas or Eastern District of Texas, the judges there, particularly Judge Albright, tends to schedule trials early on and schedule them within 18 months of when a complaint is filed. Now at the PTAB, you hear that number and you realize, well, 18 months is generally what I have between when I file and when my final written decision comes out. And so now you're in this kind of race to get your petitions filed. So if you're a defendant in a rocket docket jurisdiction, you have to start developing your invalidity case as soon as possible after your complaint is served, or you're going to miss that timing window to get your invalidity case in front of the PTAB. So this is accelerating your investment in the litigation. You have to start developing your invalidity case You're understanding your infringement exposure and claim construction really almost at day one when the complaint is filed. Now, looking at general plastics and 325D, this adds additional layers of complexity for a defendant petitioner. And when I talk to my clients, I say when you step into one of these cases as a petitioner, you have to have the full view of the field when you start. So you have to understand whether there were any prior IPR proceedings, because as a petitioner, you want to win the race to use the best prior art in front of the PTAB. You want to be controlling the narrative on the strongest aspects of the case. But you also have to understand the prosecution history and the prior art that was applied before. And not just, you can no longer just say, well, this reference was never used, therefore I'm clear. You have to look at the content of that reference to make sure you're not supplying another reference that's nearly identical in its technical teaching. So that adds an additional complexity. Now, you mentioned the SAS-based strength discretionary denials. Early on, petitioners tended to throw everything they had into a petition because they didn't want to leave any prior art on the table. And the result was a lot of grounds and a lot of them being fairly weak. Well, you can't do that approach any longer, because if you have so many weak grounds outbalancing the strong, then you could get a discretionary denial because the board has to institute on everything now. And if you have a lot of weak grounds, it's a waste of their time to have to listen to briefing on all the weak grounds. So you have to make sure you're putting your best foot forward. And one final point I know is space. And as a petitioner now, you have to proactively address Fintiv, 325D, possibly general plastics, and we'll talk about RPI and privity, which you're going to bear the burden to show you're not time barred. So a petitioner could spend 20 to 30% of the really limited words you have for a petition kind of addressing these factors, and that impacts your ability to present your merits case.
That's so true. Now, it certainly puts a burden on the petitioner. Leston, how as a patent owner are you able to maybe take advantage of some of these additional hurdles or obstacles that the petitioner has to overcome?
Yes, Herb, and everything that Lori said brings a smile to patent owners, and it's undeniable that getting a discretionary denial is a major tool in a patent owner's tool shed. The stats bear it out. The stats show that as a patent owner, if you can get denial of institution, that puts you in the best position to remain unscathed, essentially, escape the proceeding with no claims being effective. So when we speak about the Fintiv factors and discretionary denial under 314, early on as a patent owner, when you're asserting your patents, that may affect which jurisdiction you choose. As Lori mentioned, if you have the ability to assert your patents in the Western District of Texas or the Rocket Docket Eastern District of Virginia, then you probably will leverage that because you're expecting that proceeding to be very accelerated. 325D and prior art, years ago there was a thinking that during prosecution as a patent owner, you didn't want to do a prior art search. That's starting to change. You do want that best art in front of the examiner so that when you do assert your patent, you can be rest assured that probably the best art is available before the examiner, and any art that's cited by the petitioner, you can hope that you can undermine a petition in using a 325D type argument. And, I think just discretionary denial as a whole is just super effective for a patent owner because it may be dispositive of an entire PTAB proceeding without the board ever reaching the merits of the case. And that's very effective because at that point, there will be nothing in a record that could potentially harm the patent owner down the line.
I totally agree. So I want to get the board's perspective. I know there's a lot of litigation going on, and we can't get the judge to talk about some of the controversial stuff, which is great. But I think from a practical standpoint, it's always kind of curious to address how much of this discretionary denial kind of pre-rebuttal or rebuttal are you supposed to put in your petition versus maybe trying to get a reply after the patent owner raises that issue and then trying to address all that stuff in the reply? As Lori pointed out, there's a lot of constraints on word count, and if you spend half your petition talking about what might be a defense for the patent owner, should you just maybe hold that back and wait for a reply? Judge Bonilla, what do you think? Or what's the board expecting in these kinds of cases?
Well, thanks, Brent. One thing that I wanted to start out with is, over the years as PTAB has matured and as the stakeholders have matured in our practice, we've heard a lot of feedback from stakeholders about how to improve our practices. And some of them have included some of the changes that we are talking about here with serial petitions, parallel petitions, and the impact of proceedings in other tribunals. So last October, we actually published a request for comments asking for feedback from the public. And we asked 7 questions about these things, as well as other considerations relevant to discretionary denials. And it turns out we received over 800 comments. So a lot of people commented, ranging from individuals, law and trade organizations, law firms, companies, and actually 3 senators commented as well. So, so that was really great to get that feedback. The office published an executive summary of the comments back in January, and the office is right now reviewing and considering all comments. So, whether we put into rulemaking what already existed, whether it might be modified a little bit, stay tuned. In the meantime, however, practice goes on. And so I highly recommend, if you are appearing before PTAB, that you be very familiar with our current precedential case law and our trial practice guide as it relates to 314A and 325D. And make sure to argue your position prior to institution. So, we recommend raise the arguments and provides evidence and support in your first available paper. So that'll be the petition for the petitioner or the patent owner preliminary response for the patent owner. And keep in mind, talking about the page limit for, is set out in the trial practice guide for parallel petitions. These are petitions that are filed challenging the same patent around the same time, multiple petitions filed around the same time. As outlined in the trial practice guide, the parties, each side can file a 5-page paper, a separate paper. And you can actually request to do that otherwise. If it looks like, for whatever reason, the issue is going to be a big one for you and you're worried about page space, you can actually request it, pages to do as a separate paper. So that's an option if you're really worried that, for example, the discretionary denials are going to take up, 40 pages of your 60-page brief. That's something that you can raise, although you better have a really good reason, because it's not going to be just willy-nilly. But importantly, replies and surreplies are possible prior to institution. So request that if you think you need it. The thing to keep in mind, though, is those papers need to be responsive to the prior paper. So it really is best to bring up your points that exist, to bring them up, as soon as you can, because it puts you in the best position to make the arguments. So generally, that's the advice that I would give at this point, without diving too much more into it, because stay tuned in response to our request for comments.
Okay, and Herb, in light of what you've heard and all the cases you've been involved in, how is the discretionary denial situation affected your practice and kind of the practice overall?
Well, I think from both patent owner and petitioner perspective, this just as Lori said, multiple layers of complexity on top of what we were dealing with before, and so that's an issue that has to be taken up with clients right from the beginning. It doesn't matter which side you're on. Most folks think that going back from 2012 when the first petitions were filed, that really the only issues to be addressed by the board were the substantive prior art issues. Yeah. And that's turned out just not to be the case in a wide variety of cases. And we'll talk about more issues today that don't fall into the discretionary denial bucket, but definitely add further layers of complexity. So I think that this is a big part of the layers this is a big layer among many of complexity.
Well, that's a great segue, Herb, because as we move through these topics, the next one we want to hit on is printed publication, and as for the audience's benefit, for the IPRs, and you're limited to printed publications to attack a patent. PGRs, you're not so limited, but still printed pubs become are pretty important grounds for attacking patentability. Early on, we saw a lot of references that were cited as printed publications from the internet. Maybe they had a copyright date or some other date. Those didn't seem to be too problematic. But we've seen, at least I've seen, kind of a stricter approach now to what is actually going to be deemed to be a printed publication, and patent owners beginning to really, or in the last few years, have really begun to challenge that. So let's talk to Lori again as a petitioner. How have you seen the printed publication issue evolve, over the past almost decade now?
Yeah, and this is another area that I think there's been a dramatic shift since 2012. Excuse me. I think in the early days, if you had a reference and it had a copyright date, it generally got through the institution hurdle and sometimes even through final written decision just based on that copyright date. But in the last 3 or 4 years, you've seen a dramatic shift to what a petitioner has to do to prove up printed publications. And I want to stress something that Judge Bonilla referenced, was being familiar with the board's precedential decisions, which are all available on the PTAB's website, which is really helpful. But Hulu versus Soundview Innovations is the case where the board set out what, as a petitioner, you need to do to prove up printed publication. And you can't just go in with saying, look, there's a copyright. You have to have evidence sufficient to establish a reasonable likelihood that the reference was publicly accessible before the critical date. So you have to show that it was disseminated. You have to show, that it was published. You have to show a lot, more than just the copyright date. And sometimes your best prior art are some of these conference proceedings, but now you have to actually show that it was presented at the conference and ended up disseminated to some participants. Yep. So it's a higher hurdle than before. And I think it's generally a good practice. And as a petitioner, another thing you have to address early on.
And you're recommending that be done in the petition and not wait for a challenge, by the POPR or later in the trial.
Oh, absolutely. I'm very conservative in my approach. So you should gather as much information at the petition stage when you can freely introduce your evidence as you can. So I look at libraries, I look for roadmaps, for example, things like citations and other papers. I will reach out to authors, I'll reach out to conference, so you really need to do a lot of legwork. And this also can take a good portion of your word count, proving up public availability in your petition.
So keep you guys in your roles. Leston, how do you take advantage of maybe a shoddy presentation of a printed publication, or maybe a petitioner that kind of doesn't really do all of the conservative shoring up that Lori's suggesting? Yes,
and as Lori mentioned, this is definitely one of the areas that has evolved over the years. I remember times when, even on the petitioner side, a copyright date would have been more than enough. And so, as a patent owner, if you receive a petition and you see that it is not a standard patent, it is some article that may have been disseminated at some conference, you look to see what additional evidence the petitioner has provided to prove up the public accessibility of that document. You check to see whether there are declarations. You check to see whether they've submitted any library records or anything like that, or any other evidence to prove that up. And if that is lacking, then you attack it because at that point, the petitioner has not met their burden. And this is important, and to orient everyone, because these proceedings are looked at from a person of ordinary skill in the art. And so that's at the time of the invention. And that's important because if you have not established that a document was not available or accessible, essentially it's secret prior art. A person of ordinary skill in the art wouldn't have had access to it. And thus you should not be allowed to rely on it to support any arguments.
Yeah. So Brent, one thing about the pandemic that was hard on petitioners is a lot of libraries, or almost every library around the world, has been closed during the pandemic. So trying to find evidence to support public accessibility was really quite challenging during the pandemic. So I think that the board recognized that. I feel like the board recognized that, but it was really challenging gathering that information.
Have you actually seen, I wasn't asked about your cases specifically, but have you seen petitioners actually kind of, fall on the COVID sword and say, sorry, I could have done a better job if I had access to the libraries, but COVID prevented it?
I haven't, but I will say I've papered my petitions with as many library records as I could find on the internet. But maybe Judge Bonilla has seen something.
Yeah. So maybe not specific cases, Judge, but what have you seen, and what's the board expecting these days with respect to proving up your printed publication, particularly in the petition, not waiting for the patent owner to challenge it and then putting out your case?
Yeah, I mean, the thing to keep in mind, and our case law has made this clear, is that the burden is on petitioner. It's on petitioner early on to show a reasonable likelihood that it's a printed publication, and then after institution, the burden remains on the petitioner to show by preponderance of the evidence. So that's something to keep in mind. And you mentioned the Hulu case, Lori. That was a big one as it relates to prior to institution. So that's worth taking a look at. But what do we look at? We definitely look at indicia on the face of the reference itself. So if there's a copyright date or date stamps, things like that, we look at that. And depending on what it is, that may or may not be sufficient. The touchstone for printed publication, as somebody mentioned, is public accessibility. So we're looking to see if it was disseminated or otherwise made available to the extent that a person interested in ordinary skilled in the subject matter or art, exercising reasonable diligence, can find it. So that's what we're looking at. And so when does this issue come up? I mean, some of my co-panelists mentioned it, but it could be documents stored in a library. It could be oral or slide presentations at a conference, advertisements, online versions of documents, websites, package inserts, clinical trials, video recordings, things like that, things that are not the traditional, okay, I have this paper that was published in Science, or I have a patent that was published. Those things are obviously much more clear. So I thought I would talk about a couple examples of what we look for, sort of what's the best practice and what's the next best thing kind of thing. So I was thinking about, for example, a thesis that's in a library. Some of the best evidence you have could be testimony that is from a person that was responsible for actually putting that document there. When the document was received, how it was cataloged. And so if you have somebody with actual knowledge of the document itself, obviously that's the best. The next best thing is to have testimony by a person with knowledge of the procedures that were in place at the time. So maybe they didn't see the actual document, but they know what they normally do with theses at that university, for example. The next best thing, and this may or may not be sufficient depending on what other evidence you can put together, is a person who can testify about procedures that are regularly followed, generally, even if they didn't know what happened at the time. So it's sort of a grade, if you will, as you can find out depending on what you can get. Another place where this has come up is in conferences. So like oral presentation slides or poster presentations, you see that in science conferences. Again, the best practice is, if you can get it, is testimony by somebody who actually attended it. So for example, if the material was distributed but not indexed, you can prove with, evidence or testimony about an attendee or somebody with actual knowledge, such as a conference organizer, that the document was available and it was disseminated at the conference. If it wasn't distributed or indexed, if you don't have evidence of that, you want to prove with, maybe somebody who was there who had a photograph of the slides or something like that. And then again, the next best thing is, evidence from somebody knowledgeable about how these things usually happen at the conference, or somebody who knows how things are generally prepared at a conference of this sort. I mean, it's sort of how close you can get to it. But what you're looking for is that was publicly disseminated, that there was public accessibility, that it was accessible to the public. And, just generally that somebody could locate it either through indexing or searching or what have you.
Well, Judge, I have a question. Much of what you just recited, you could go through the federal rules of evidence and find specific rules pertaining to, for example, the practice of maintaining records and so forth, the sort of past recollection recorded thing. Early on, we didn't really see much focus from the panels on the specifics of the federal rules of evidence. Do you see a trend toward paying closer attention to them?
I think generally, like you said, I think a lot of people just took it for granted, but then I think people started questioning. I think probably, the first time I really saw a case of it had to do with a poster that was presented at a conference. And it became clear to us that I don't even know that the petitioner fully realized that they needed to do anything to show that it was publicly accessible. And so we denied institution in that case because there was literally no evidence at all. And so I think as our practice developed and as, all the parties got more sophisticated, including, patent owners who are dealing with challenges, people started making the arguments. They started saying, hey, look, we can't assume that this is publicly disseminated. We have absolutely no evidence of it, or we don't have very good evidence. And so I think as our practice developed and people became more sophisticated, they realized, whether a piece of prior art really is a piece of prior art is an important question in our proceedings. So I just think as people got more sophisticated, they started making the arguments. And then as we started making the arguments, we started developing our case law, and you see things like Hulu and cases like that came out. So I think people just got more educated, they got more sophisticated, and that was reflected in what we did in our practice as APJs.
So we've had a couple of questions. The first question on 325D, if I'm not sure I understand if is the questioner, if they can repost that question, is the question, why does 325D relate to inter partes reviews, and because the question says not just post grant reviews. Are you saying should it only be post grant reviews and not inter partes reviews? I'm not sure if that's the question. Because right now it applies to both. So could you repost that with respect to inter partes reviews, and is that really the focus of your question? We're going to talk. We might hit on joinder. The second question is about joinder and unilock, and we're going to turn to that issue in a sense now. If we don't answer your question in this discussion, then maybe let us know, because as we move through these topics, you see we're kind of hitting on pitfalls for the petitioner, things to be wary of as you prepare your case. So we're turning now to the issue of privity, real party and interest, and the 1-year bar. And again, as a basic background, the petitioner has to identify not only the real party and interest filing the petition, but anybody that is in privity with that real party and interest. And you have a year from the service of the complaint to file that petition. Possibly some opportunities here as the law evolves and develops in what is a privy and what is not, and what's an RPI and what is not, and how possibly you could file suit against one of those, have a IPR potentially instituted, and then maybe sue somebody else. Like let's say you sue a customer first, and then you sue a manufacturer. So let's start this time with Leston as a patent owner. Speaking from the patent owner's perspective, how's the law changed here, and how is this issue something that a patent owner and perhaps a POPR, a patent owner preliminary response, might try to take advantage of maybe a deficiency here in the petition?
Yes, and so as you stated, Brian, an IPR may not be instituted if the petitioner requesting the proceeding is filed more than 1 year after the petitioner or a real party in interest or someone in privy served the complaint or was served a complaint. And so as a patent owner, I think one of the most important things is understanding the corporate structure or the business relationships of the alleged infringer when you're filing suit. And if you are then turned around and a PTAB petition is filed against you, you want to make sure that everyone that has control and a vested interest in the proceeding is listed as a proper RPI. You don't want to obviously overreach and ask for folks to be brought into a proceeding that don't necessarily belong there. But if you can prove and establish that another entity is exercising control over proceeding, you want to bring that to light. And sometimes it may not be clear. So as a patent owner, requesting additional discovery, even at that early stage, I would, suggest that if you have strong evidence or strong suspicions and that you can back it up to show good cause as to why you should get additional discovery to flesh out that RPI issue. And even if it does not lead to a denial of institution, it's a good practice, because at the end of the day, you want, for example, estoppels to apply down the line to all parties properly.
So Lori, again, as petitioner's spokesperson here, what are you recommending and doing with respect to trying to shore up the RPI issue so you don't get caught with your pants down by less than here when you tax your petition?
Yeah, and this goes back to my petitioner theme, that a petitioner has to understand the full field when they start preparing and assessing their PTAB strategy. The one, I think, frustrating thing for petitioners on this issue for RPI and privity is there's no real bright line rules or cases. I wouldn't even say the line is dim. It's really an amorphous blob that you have to deal with. And it's because it's a flexible approach that takes into account equitable and practical considerations when making the determination. And when you have different panels having different viewpoints, you can never be quite sure, how your facts are going to be balanced. So going in, you have to look at, for RPI, is there a non-party who could be a clear beneficiary that has a pre-existing established relationship with you? So you have to assess all your relationships to see if anyone could benefit, would be a clear beneficiary from your IPR, because that could make them an RPI. And if they were sued for infringement of this patent and served more than a year ago, you could be barred. The privity issue is even more complex, because you have to look at whether somebody would benefit if the relationship between two parties is sufficiently close so that one should be bound by the trial outcome. So it's a different analysis, but very closely related, but both can kind of bite you if you're not aware of them. So you really have to analyze that. And if it's an issue, again, get out in front of it in your petition when you have the opportunity to fully present your facts and your evidence, because it is petitioner's burden to show that they aren't barred under 315B.
Well, okay, so Judge Bonilla, when this issue comes up, and it seems to come up pretty regularly by patent owners, and oftentimes discovery is requested. It seems like oftentimes it's not permitted, it's not authorized. But what's the board expecting, in the petition, and then what are you seeing as far as allowing or permitting discovery to kind of flesh out these issues?
Yeah, one thing I wanted to mention, I think Lori and Leston talked about this a little bit, but it is the petitioner's burden, and it does turn out to be a very highly fact-dependent question. So it can be quite complicated to determine who's a real party in interest or privity. It's not a trivial inquiry. With that in mind, I wanted, and that's we have two recent cases that we designate precedential, which I would encourage you to take a look at. One was RPX versus Application Internet Time. But another one, which nobody mentioned yet, is the Shark Ninja case. And that's a really important, because one of the thing that the board said in that case, which is that The board doesn't really need to even address whether an unnamed party is a real party in interest. If it's the case that even if it were, it wouldn't create a time bar or estoppel preventing the case from going forward. So it's not even worth the bother unless, for example, there's a 1-year bar situation. What we saw early on is sometimes people were disputing real party in interest because they would say, hey, if you didn't list your real party in interest, you should deny the institution of just on that basis alone. And we have precedential cases that say, no, it's not a jurisdictional thing. It's something you can fix. You can fix it without necessarily messing with your original filing date. So if it turns out that whoever it is you're alleging is a real party in interest, they wouldn't have been barred as of the original filing date either, then the board isn't going to go into this, heavy, labor-intensive, lots of pages inquiry and briefing about real party in interest. I will say, though, however, sometimes it is relevant, of course, and how has the board been handling it? I would tell the parties, if you need it, you can request to file a motion for additional discovery. But we expect the parties to negotiate we expect the parties to negotiate in good faith and figure out what they can agree upon and narrow the issues about, where they're really at an impasse. They need something and they're not getting it, or they don't want to give it, and so on. Because a motion for additional discovery, it'll be denied if it's not going to uncover anything favorable to the person who's requesting it. For example, it's relevant to the bar, it's relevant to estoppel. And you have to be careful. Discovery at PTAB is not the full-blown rodeo that it is in district court. We have case law that talks about how it's a little bit more narrow. And one of it is it can't be overly burdensome. So you can't ask for everything under the sun. Make sure it's really tailored to what you need. And I would tell people, if real party in interest is an issue in the case, if you think it is on either side, you need to, you want to raise the issue and request any motions for discovery or what have you, or just, to modify your mandatory notices. Do it as early as possible. Because if a party asks too late, we had one case, for example, if you ask a month before the oral hearing, all of a sudden it's a new issue. I think a motion for discovery, for example, is likely to get denied. As far as pre-DI, pre-decisional on institution, I would say ask for a reply and surreply if you need it. The board generally is pretty liberal about granting the ability to file a reply and a surreply if it looks like it's going to help resolve the issues. And the bar, for example, and the real party and interest and things like that, these are things that can help us decide whether we should institute in the first place. So we want the parties to bring it up early. So if you need to flesh it out in briefing in a reply and surreply, let us know.
Okay, that's helpful. And I would just, to kind of mimic or follow on Lori's comments about, kind of getting stuff done up front. I know replies are available and surreplies are available. This is not a question, Judge. It's just a comment for the audience. But I will note that oftentimes those are very constrained. And so if you get a reply, it might be 3 pages, 5 pages, and it's going to be limited to what the other party argued. So don't, when you're dealing with these issues, don't say, oh, I'll deal with it in a reply that I might get and then be able to address it. Because you might not get it. The panel may say, no, you don't get a reply. You should have figured this out up front. Or 2, you might get it. It might be like, oh, you got 3 pages. So get in your petition if you can. That way you have pretty much unfettered access to what you want to say. So I'm looking at the questions now. So the 325D question, I think is pretty straightforward. 325D applies, it says to all PTAB post-grant proceedings, yes. There's really only 2 now because CBMs have expired. There may be some trickling through, but the 325D applied there as well. So whenever there's either an IPR or a PGR, and the difference really largely is just IPRs are patents that are pre-AIA, PGR patents that are post-AIA. Some other differences, but essentially if there was art that's presented in the petition that was already considered by the patent office, or similar issues that were presented in the examination, or maybe in a re-exam, or maybe by the office in some other context, then that can be used as a basis for discretionary denial in either an IPR or PGR. We just talked about RPIs, privies. I don't know if we really hit this joinder issue. Can you guys see the Q&A on your screens? The question was how the Unilock v. Facebook decision on joinder, how it affects petitions and how petitioners file petitions. So I'll just throw that out. Does anybody want want to tackle that one. It's related to privity, but not exactly. Any thoughts there from the panel or for anyone on that question? We can all speak at once, I see. So I think the answer is similar in that this is an issue that you're going to have to deal with up front, and if there's a potential for another party coming in that wants to join, you're going to run into this 1 year bar problem, and that's why it's so important to be thinking about these things up front, is because if you have a joinder, a party that wants to join, are they going to destroy or run into that 1 year bar issue? I'm not sure I understand the last question, which is the difference between second best and third best evidence on printed publication. So if the audience member could it looks like they're repeating it now. But if you could repeat that, because I don't recall a discussion. Did we talk about second best and third best?
I did a little bit. I talked about best practices versus next best, and it's kind of a gradation of who can do it. I mean, if you have somebody with actual knowledge about the actual thing, like somebody who attended the conference, for example, versus somebody who maybe they don't remember the exact event, but they attended that conference. So they know generally, this would be next best. So they know generally what would happen at that conference. A third best, for example, would be, well, I didn't attend that conference, but I attended conferences like them at the general time frame, and I know that this is generally what happened at conferences. So that it's just sort of you get as close as you can. I mean, basically the idea is to get as close as you can to a person with actual knowledge about the actual thing at that time. And sometimes you can't find that, so you start going into gradations of what you can find.
Okay.
Oh, Judge, that's sort of the other indicia of reliability, kind of the catch-all in the federal rules that the board would be relying on in that instance?
Yeah, you raise a good point. The board follows the federal rules of evidence. So to the extent that, that comes into play, definitely take a look at that. That impacts us as well.
So let's change gears a little bit to a kind of another interesting topic, maybe not too controversial, but secondary considerations. In district court, we spend a lot of time in litigation arguing over, these objective indicia of non-obviousness as patent owners and putting on evidence of commercial sales, long felt need, all of that. In my experience, that doesn't seem to get a lot of traction at the board, and so we tend not to, or at least we've kind of stopped making a lot of those arguments. But I guess, Herb, what's your sense of secondary considerations? And I think you're aware of the Ameren petition for cert on this issue. So can you kind of fill us in here?
Well, just generally, as far as the board's decisions are concerned, it is fairly unusual to see an outcome determined by evidence of objective indicia. And so I think the relevance of this petition that you referred to, the Ameren petition, is that it looks like folks would like to get the Supreme Court to weigh in on what's the process for considering the evidence of objective indicia. So the background here, this is an ANDA case, Ameren against HICMA, and there was a bench trial in the District of Nevada, and the judge's opinion, very detailed, cataloged all the prior art, evaluated the expert testimony concerning that, and at the end he kind of said, well, it looks like the challenger here, the defendant, has made a prima facie case of obviousness, and from that point jumped into the evidence of non-obviousness being the objective indicia evidence. And so again, very detailed analysis, going through and weighing and deciding What part of that evidence was entitled to consideration? Well, it was all considered, but what part was persuasive and what wasn't, and finally deciding that all of that evidence taken together, along with the obviousness evidence, the prior art evidence, left him with the view that the claims were unpatentable as obvious. So that happened to the district court. That went up to the Federal Circuit, and there was a Rule 36 disposition. From there, Ameren filed a petition for cert, which is pending now, and you could find it on the court's website, basically taking the position that this whole notion of having a prima facie case of obviousness conflicted with what the court had said in Grant. Now, it's a little hard to tell here what the real question is. Is it a matter of jargon when one separates the prior art issues from the objective indicia issues, or just exactly what the point is here? But I think that case is worth following because, of course, if the Supreme Court takes that case, it's going to have an impact on what we see from the board in terms of considering that sort of evidence.
Thanks. Now, so Judge Bonilla, not to be too snarky, but is the board interested in secondary considerations, or are we just wasting our breath as patent owners and wasting our word count in getting into that?
So we are absolutely interested in secondary considerations. The Federal Circuit has made it clear that we must always take them into account. I mean, basically, we're bound to do so, and we'll get reversed if we don't. So one thing I will say, though, is in situations, we have seen that parties don't always present a very good case. That means fleshed out arguments, sufficient evidence. Basically, we can't rule in your favor if you don't make the argument and you don't give us what we need, the evidence and whatnot to make a finding in your favor. So what do we tell people? What's effective ways to establish or disprove secondary considerations? First, the parties are going to have to do the work, and they're going to have to muster as much evidence as they can. I mean, if there's long felt need, failure of others, industry praise, copying, commercial success, you're going to have to put together the evidence to actually show it. I can't tell you how often I see people, it's almost like a thought afterwards or a throwaway argument about secondary considerations in like a paragraph or two. I would just say, look, if you're going to do it, go for it, right? You're either all in or don't bother. But I will say that it can be really important. Secondary considerations can be quite important if the case is close on obviousness. The fact that you can make a showing. We have our electrosonics case, for example. That's a good one to keep in mind. I would also say you have to be cognitive of the fact that if you're going to assert secondary considerations, there needs to be a nexus between the evidence that you're showing and the claimed invention. So again, take a look at that electrosonics case, which was designated precedential in April of last year. It has a good explanation about nexus post-Fox factory by the Federal Circuit. Again, I would say for patent owners, be careful. Don't short shift what you're doing. Go all in, make sure you have all the declarations, that you have evidence to support those declarations. One thing we don't like to see, for example, if you make a conclusionary statement in your paper, and then you cite to a declarant who makes a similarly conclusionary statement that's not really going to help you. So you want to cite the declarant, you want to cite the evidence they're relying on, and then in the declaration itself, really flesh out what the position is, why that position is, and all the evidence. You can cite even more evidence in the declaration than you might even in the paper. So you really want to make it ironclad from an evidentiary standpoint. One thing I would caution petitioners when you're in this situation, and this goes to 325D issues and things like that, you're going to want to make sure that you address any allegations of secondary considerations that the patent owner made during prosecution or in litigation in another forum. So if you know about it, if you know that secondary considerations are an issue in your case, you might want to go ahead and raise them, head on. Don't ignore them, because you might be in a situation, as you mentioned, Brent, where you're in a reply setting or a surreply setting, and you can't really make the arguments because you can only really respond to what's raised before you, and you can only respond to evidence that was raised before you. So you might not be able to make your case as well. So if you think it's an issue for it, don't hide from it in your briefing.
That's really helpful, and I guess my introductory comment was a little snarky, but I think you're right, Judge, that a lot of the times that you see patent owners raise secondary considerations, it is pretty hand wavy. And this key issue that you point out of nexus, which the Federal Circuit has really hit on and the district courts hit on, they say, look, we've sold this product, we've had a lot of sales, or there's been this awards and stuff, but they really don't tie it to the claim invention. And there you're kind of stuck, right? They're just not going to be able to make up. That's not really going to be sufficient.
Can I actually just add one more thing?
Of course.
Yeah, from the patent owner's perspective, normally secondary considerations or objective indicia of non-obviousness comes out, way after a patent is granted. But there are some circumstances where that evidence may be present during prosecution. And if that evidence is available, I would suggest putting that into the record during prosecution, because once again, that's another hurdle that petitioner may have to overcome when attacking it in their petition for all the reasons that we discussed before.
That's a great point. So for all the patent prosecutors out there, maybe you don't need it to get the claims allowed, but thinking further down the road about if this patent ever gets challenged, maybe this is a good landmine in a sense to plan in your prosecution, so that unless Lori's on the other side, the petitioner might miss it. So there's a question here on supplemental evidence. I'll try to field it, and then I'll throw it out to the panel. So the question is the supplemental evidence can be used to prove up public availability. So we were talking about printed pubs, and so my response would be, the problem with supplemental evidence is that you generally have to get authorization to file that. You got to show good cause for why you didn't have that information available, or why you didn't present it earlier. So yes, I think if you can get the panel to authorize supplemental evidence to try to prove up something as a printed pub, yeah, you could put in whatever you need to do. I think supplemental evidence is pretty broad, but you still have the hurdle of getting the panel to authorize the submission of that evidence, and it may be constrained in how much you can present. But with that,
yeah, Brent, just I guess a couple things. I think there's some general confusion between supplemental information and supplemental evidence. So supplemental evidence is what you serve between the parties, and it never gets put into the record. So you can't use that to support your case unless it gets into the record. And the way to get the information into the record is to file a motion for supplemental information, and that has to be done within 1 month after institution. And I've found that the board is generally fairly open to getting additional information related to public accessibility in that window, if you can kind of explain why you didn't present it earlier. So I agree, you have to ask the board's permission for supplemental information, but don't think you can rely on supplemental evidence that you just served between the parties to prove your case down the rood.
You're right. And
sorry, I was just going to say that's great, because that was effectively what I was thinking too. People do get confused, but it's nomenclature, but supplemental information versus supplemental evidence. And I would just say that from what you said, that if it is within that month window and it will help resolve whether something is a printed publication and it wasn't necessarily resolved at the institution stage, that is something that the board is open to looking at to get it resolved and get that evidence of record early on. But you have to be careful. You can't make an argument for the first time wholesale. You have to tie it back to something that's going on in the trial. So, you do have to be careful about that. If it's something that you could have raised in your petition and you didn't, for whatever reason, that might have an impact, just as you mentioned.
Right. And if I could just chime in on this whole difference between supplemental information and supplemental evidence. Lori mentioned a moment ago, well, that evidence is not going to go into the record? Well, the typical function of supplemental evidence is to cure, say, a hearsay problem or some other evidentiary problem of that sort. Now, where that evidence goes into the record is in response to your opponent's filing a motion to exclude that evidence. So in that instance, it will be in the record. The board will see it. You will get a ruling on it, assuming that the resolution of that evidentiary issue makes a difference at all in the resolution of the case. It might be that the panel takes a look at it and says, hey, this is, yeah, I agree with you, but this is a big so what. I'm not going to spend the time in the opinion discussing it.
Okay, so let's turn to our next interesting topic that Judge Bonilla actually suggested as we were preparing for this, and this is dealing with the fast track appeals that the Patent Office in the examination context has recently introduced, and the potential to use fast track appeals or ex parte re-exam or reissues as a patent owner to kind of prophylactically protect your patent or IPR proof it from an IPR or a PGR. So maybe we'll, because this was kind of your insight, Judge. Can you kind of give us a sense of this concept and how the fast track appeals are working and how that might be used as a patent owner IPR proofing?
Yeah, and just to give some background, we may have IP litigators on the line, so they may not know what the fast track appeal pilot program is. It's something that we started last July, and these are for ex parte appeals. So if you're in prosecution and you get a final rejection from an examiner and you're appealing to the board during prosecution, this is a vehicle for us to fast track those appeals. So those ex parte appeals are taken out of turn. And it's not very hard to do it. You file a petition, you pay a fee. I would just flag that actually we just did a new fast track appeals pilot program for COVID related inventions, and then you don't even have to pay the fee. The goal is that we would issue a decision in ex parte appeal within 6 months from the date that the petition is granted. And today, and that the petition can be filed after the jurisdiction passes to the board. So this is basically after the briefing. But today we're doing it pretty fast. It's closer to 2 months. So it really is fast tracked. We talk about there's a limit on how many petitions we might do a year, but we haven't come close to hitting that limit. And the reason why I raise this with Brent is because, why would an IP litigator or an IP practitioner care about what happens in patent prosecution? And the answer is 325D. This is a discretionary denial with the idea that, IPRs are generally triggered by litigation. So you're going to care, you might care about whether you could file an IPR and 325D implications. We haven't talked about it too much, but we have one of our most recent cases is Advanced Bionic. It lays out a two-part inquiry into whether 325D applies. And it's the first factor is whether the same or substantially the same art was previously presented before the office, or whether the same or substantially the same arguments were previously presented before the office. And if either one of those things are satisfied, then the board will look at whether the office erred in a manner that was material to patentability. And the thing to keep in mind is that if reasonable minds can differ about whether there's an error, that wouldn't count as an error here. So it has to be something, for example, the examiner really missed something, they missed a limitation, or they missed something in the prior art. So the point is that what happens during prosecution matters. So for patent owners, they may want to think about this. They may want to think about before they sue specifically, do you have a continuation still in prosecution? If you don't, do you want to go into reissue or re-exam to basically put all this stuff in the record? Do you want to put secondary considerations in the record? Did you do your due diligence before suing and realize, oh no, there's prior art out there that I know I can address that I didn't address before? You can go into prosecution and you can go ahead and put that on the record. So I would encourage, I think, Leston, you mentioned this, but I think it's really important, do your due diligence before you sue. Think about any challenges that might come up. Do your prior art searches at that point for sure, engage in active discussions before an examiner about them. You want to flesh out those secondary considerations. You want to make sure you get all the claims you want from broadest to narrowest. I raise that because oftentimes when we find a claim unpatentable, it's not because there wasn't something patentable there. It's because the claims were too broad or whatever. They had some kind of problem with the language itself. So keep that in mind. And then I just wanted to add, applicants can control how long prosecution takes. A lot of times people take, the full 3-month extension for everything. But if you don't do that, if you want to go fast, generally speaking, the office goes really fast too, especially in re-exams and reissues, and obviously on these fast track appeals. There are options to move prosecution quickly if you realize, okay, I think I want to sue, but I see that there's a problem and I want to, try and take advantage of 325D as much as possible. There are ways to make that happen pretty quickly. So I wanted to flag that for people because I think a lot of IP litigators, when you're thinking about strategy for litigation, you need to keep in mind these levers in prosecution as well.
So, Lester, Judge Bonilla called you out. Given that we IPR folks are kind of the tail and the litigators are kind of the dog, how can we, as the tail, wag the dog? Can we get some of this stuff in front of the patent office first before the litigators, file the lawsuit?
Yes, and to echo everything that Judge Bonilla said, as a PTAB practitioner representing a patent owner, there's no perfect patent out there. All patents have certain warts, and you wish these claims were a little bit narrower, stronger, whatever it may be. And I do think fast track appeals is a very effective mechanism to one, identify any potential weaknesses in your claims and shore that up, and then two, exactly what Judge Bonilla said, to pepper the record and litter the record with prior art and any additional evidence that you think will help you to IPR proof as close to IPR proof your patent. And I do think that's definitely a strategy and something that patent owners should be thinking about before even asserting their patent. I think often when asserting patents, some patent owners do not really appreciate the potential weaknesses of their claims. And if they can do that upfront, it will definitely, hopefully, resolve a lot of heartache and money spent down the line.
Counterpoint, Lori?
Yeah.
Oh, I'm sorry, Judge Bonilla.
Oh, sorry, Judge Bonilla.
I was just going to make one point, if you don't mind. Sorry to interrupt you, Lori, which is that, we realize that sometimes when you're in original prosecution, there may not be a whole lot of money on the line yet. There may not be a commercial product. And it could be that by the time you've got your ducks in a row and you're really ready to sue, you have a product, there's a competitor product. That's that's years later after prosecution has taken place. So one of the things that when we were going through some of our requests for comments, we got feedback that stakeholders wanted to know more about how reissue and reexam actually works. So we actually published a notice back in April of 2019. I just wanted to flag that because it talks about how you can go into reissue or reexam either before, during, or even after an AI trial. So I just wanted to make sure that people understand that. And there's a lot of information in that notice about, how re-exams work and how reissues work. And so it's good to take a look at that because if it's really far down the line, you may have to go back into prosecution with those vehicles. So I just wanted to flag that.
Lori, we interrupted you.
Oh, no problem. So again, I'm going to go back to my theme of as a company defendant, understanding the full field. And I think one of the things that as a defendant, you have to look at, even if you just received a letter from someone saying, I have these 5 patents, you're infringing, and you respond back, I don't infringe these patents. Well, you need to know whether there's any live family members in that tree, because you've just given the other side a roadmap on how to kind of change the claims in their pending applications to possibly go after you. And with this fast track appeal, they could potentially get claims out of the office. You combine that with fast track prosecution, they could have a claim out to sue you, pretty quickly. So you want to understand if somebody has something live and be monitoring that, because if you think they might sue you on a continuation that's in the office, you're going to know what claims have been allowed in advance because of the notice of allowance. And you can start preparing for a post-grant review, which is a more powerful tool in your tool belt, because you have all the different challenges and validity challenges for you. So I think from my perspective, this puts a tool in the hands of the patent owner to use, and as a petitioner or a defendant, you need to be prepared to counter that with quick action and awareness.
Okay, and I'm paying a little more attention to the Q&A, trying to keep it more timely here. So the question is, or a point that's being made is the problem with the fast track appeals is the delay to get to the PTAB stage due to slow examiner replies. And I think Judge Bonilla indicated that they're certainly getting quicker, particularly on the fast track. I recognize, my response would be, yeah, that's always the problem, right? Is the litigators and the client have decided they want to sue, and they're going to sue on the patent that's issued, and that's number one. And if you are less than to say, hey, hold on, let's try to shore this up, maybe a continuation case, we can fix up these problems that are pretty apparent, and that'll give us a better patent to sue on. But that's still going to take months, right? And is the and then you also have the intervening rights potential issue as well. So anybody else want to kibitz on this particular comment?
Sure.
So I think part of the comment was, how long does it take for the examiner to act? Because jurisdiction doesn't pass to PTAB until after all the briefings. So there's the initial appeal brief, there's the examiner's answer, and then there's subsequent briefing if the applicant wants to do that. We actually did a board side chat recently, and these are recorded. The slides are there, and so you can check it out on our website. But it talked about how to do that quickly too. Generally speaking, the examiner's answers do happen relatively quickly. And of course, if they're not, you can flag it for the office and say, hey, what's taking so long? But generally, they are pretty fast. And so I would just underscore again, you control the clock in a lot of ways. You don't have to take your full time. You don't have to take extensions. And if you want this done fast, you know how it works when you're doing prosecution. If you actually open up the file and get started on it, you can probably get it done in a couple weeks. So, you don't have to take all this time. So you can make it go fast if you want to. And that was what that board side chat talked about, is how, you really can, you can take advantage of all the levers you can get from the time you get a final office action to an answer, even including all the briefing. You can probably do it in under a year if you really take advantage of it properly.
Oh, and I just want to chime in on Brent's comment here, is that when recommending this strategy to your client, very frequently you're not dealing with a patent counsel. There are other people involved in the decision to file a lawsuit. The commercial situation has gotten either looking like fertile ground for getting some money, or it's looking dire for some other reason. And so from the business side, the question comes, how long is this going to take? And so I think if we're able to answer, yeah, we can do this cleanup job in less than a year, that's a defined time frame, which is different from what we had to answer some time ago, which is, I really can't tell the examiner, this examiner's slow, this one's fast, and the fast track part doesn't start until it's out of his or her hands. So I think that's a useful bit of information to pass on to clients who we might be counseling on that issue.
Exactly. We've kind of switched gears, got up some more procedural stuff. So another kind of interesting kind of temporal issue is how the COVID pandemic has affected the practice. In particular, there's not a lot of in-person meetings with the board. We have a final hearing where we have typically would have an in-person presentation. But Judge, what's been the PTAB's experience here with pandemic related oral hearings? How have things been affected there?
So I think we've adapted pretty well. We were lucky. We continued oral hearings right from the get-go. I mean, for example, a year ago, March, we had a shutdown on a Friday, and our first all virtual, meaning not anybody at all was in the office hearing, was that following Monday. So we pretty much landed on the ground running. And, part of the reason why we could do that, and I think we were at a real advantage over, some of the courts and some of the other agencies, is because a lot of people at the USPTO, a lot of people at PTAB were already ready to work from home. I mean, for example, I go into the office most days of the week, but I still had the full setup at home. I had, the dual monitors, my docking station, all that other stuff. I had it set up, and I knew how to deal with things like WebEx, which is how we do our hearings and stuff like that. So we were pretty ready. And we didn't see that much impact on filings. We did have, especially early on, we had some situations where people asked for extension of time and deadlines. And when we could do that, we accommodated that. But it didn't really slow us down all that much. And what we saw is frankly, everybody adapted pretty well, including the parties. I think everybody was sort of surprised, to be honest with you, not just at PTAB, but everywhere at how well it actually did work. People were sort of the mindset that, in person is best. And people may still think that, but I think that people realize that actually you can be pretty effective on camera. And this is especially true, of course, when everybody's on camera. So everybody has the same both advantages and disadvantages. And there are some benefits to being on camera. I mean, I've heard people talk about, for example, when you're on camera, if you get a question from a judge and you don't know the answer, you can literally go like on your computer and check the record, or you can go do legal research right there on the fly. That's not something you can do very well when you're standing at the podium. Maybe your co-counsel can and give you a piece of paper, but I mean, I've seen people be really crafty about what they can do on the fly because they're sitting there looking at their computer. Also, another advantage is just the ability to IM with your co-counsel. I mean, we do that too. The judges will IM, separately to sort of talk about the issues. It's a way to communicate while you're talking. And with practice, you can actually kind of get good at that. It's a little tricky because it can be distracting, but you can get better at it. And the other thing we put in place afterwards was the ability for the public to listen by audio. They're muted, but they can listen by audio to any of our hearings. Prior to that, people, they could request it, but the vast majority of people who just wanted to watch our hearings or listen, they had to come in person. And so what we put in place was, this ability to call in and listen. And I think it's really, really expanded accessibility for students, for people who are interested in the case, for clients, for, whoever might be involved in the inventors, whoever, to just listen in and hear what's going on in real time. And one thing we had talked about is what do we expect to retain afterwards, after,
right.
The pandemic has gone over. And basically what we expect is to retain all the options you see today. We anticipate that a lot of people will want to go back to in-person, oral hearings, for example, maybe in-person depositions and things like that, because a lot of people like it. But to the extent that there are clients and parties who want to do it the way we're doing it today, it might be cheaper. It might give more access to people. We're going to, if the parties want to do it, we're going to allow people to do that, including the ability to listen by audio. So I think this thing has opened up a bit of a Pandora's box about what we can do, how easy it is to do, forced us to get everything set up, including clients and parties. So I think, I don't know that we'll ever go back to not doing that anymore at all, is what I suspect. But we'll leave that for the parties to ask. They can ask what they wished.
So, and we didn't talk about this, but just a question that came to mind is, a lot of times in litigation, there's a default, and then if the parties agree to do something else, the board or the courts are always happy to do it. But when they don't agree, which is pretty common because they don't like each other, then you go with the default. So do you think the default for like oral hearings would be back to everybody shows up in Alexandria unless both parties agree to do it by oral or to do it by video? Or do you guys have any thoughts about that?
Well, I'll just answer that. I mean, we had, even before the pandemic, we had situations where parties said, due to a hardship, it could be costs, it could be, all of a sudden somebody's mother had to go to the hospital, whatever, something happened and they say, we have to appear virtually. We accommodated that then. So if a party wants to appear in person and another party does not want to appear in person, we haven't really done that very often, but it's something we can accommodate. We definitely want the parties to work it out for themselves to the best that they can. But I think it's a really case-by-case basis about what the default would be. And I say that's especially true as we're sort of working through the pandemic. I mean, it might be a slow rollout in terms of truly getting back to normal. We have had in the past that the default would be that it would be in person. That's what we were pre-pandemic, that the default would be in person unless you ask. We may go back to that. We'll just see. We'll just have to see how it goes and sort of what people want and how it works out.
Okay. Well, I'm watching our clock, and I want to try to get through our stuff and leave room for time. So I want to do another kind of procedural discussion with Judge Bonilla. Again, one of her topics that she thought would be valuable for the audience, and that is this LEAP program that the board has established. I don't know, maybe it's a year or so. It's the Legal Experience and Advancement Program for younger attorneys, or I should say more junior attorneys, to get some experience at the podium presenting, in front of the judges. So Judge, I know we're giving you a lot of questions here, but tell us about how LEAP is going and what the experience has been.
Thanks. And Brent is being kind, because I did specifically ask if I could make a plug about the LEAP program, because it's something we're really excited about. We understand that it can be really difficult, especially it can be difficult for anyone to get court time. And that's especially true if you haven't done it before. It's honestly, it's also especially true for traditionally underrepresented practitioners, such as women and people of color and other minorities. So we wanted to create a situation where it would incentivize people to allow people to have people more junior argue earlier in their career. So we set up this program, this Legal Experience and Advancement Program, and it has two components. It has an opportunity for participants to appear in actual cases before us. And then we also provided, for people who might do that, good training through webinars and mock oral hearings. So just to give you a little background, I know we're running a little bit low on time, but just to give you a little background about what it is. For the operation of LEAP, basically, if a party gives a LEAP practitioner an opportunity to argue in an oral hearing before us, the board will grant 15 extra minutes of argument time. The party can use that additional time any way they want, but they have to make sure that they give the LEAP practitioner some kind of substantial role. So it could be a carve out. So for example, maybe they'll argue a claim construction aspect, or they'll argue some, unexpected results or, secondary considerations. You can give a piece to them so they have a time to do a substantive argument. And to qualify as a LEAP practitioner, basically a patent attorney or a patent attorney or a patent agent must have 3 or fewer substantive oral arguments before any tribunal, whether it's us or district court or otherwise, and be 7 or a few years as a licensed since they took the bar or they became a patent attorney. And one of the things that people have raised about concerns about having more junior people go, and you hear this from the clients, it's like, well, this is a bank, the company kind of, thing that's happening at PTAB. I don't want some junior associate arguing for me. And I would just say in response to that one of the things that we understand if a LEAP practitioner is arguing before us is that if they do flub it or they miss something or something happens, that a more experienced counsel can step in afterwards or while it's going on and say, oh, and by the way, I just want to clarify for the record X, Y, and Z. So even if they do mess up, there's an opportunity to fix. And we are very aware of that. We want to give people opportunity. We don't want people to sort of not do the program because they're afraid if somebody isn't perfect coming out of the box. I will also tell you, just from my experience with LEAP so far, people have nothing to worry about. In my experience, the more junior attorneys are the ones who are actually writing the briefs. They're actually the ones prepping for the depositions. They know the record like the back of their hands. And our questions generally expect people to know the record. We need answers from people who know the record. And these people, they know the record. The LEAP practitioners have been just almost mind-blowingly prepared. I mean, some of them have been just really, really good. So I don't think that people need to worry that, they're going to not be doing as well. So and another thing too is that we've had the training that I mentioned. So we have these 1 hour webinars that we've had periodically. A lot of people have shown up to them. I mean, we've had over 200 people show up to these things, which makes us think that it isn't just the LEAP practitioners that are actually coming to these trainings. But they talk about, how to use demonstratives, how to work remotely, how to do oral advocacy. We have PTAB judges talk, we have experienced practitioners talk. And we also have these mock argument programs where we have PTAB judges and experienced practitioners act as judges, and these people get a mock program and they have a chance to argue a case. It's not a real case, but it's an opportunity to argue a case and get personalized feedback. And we've done it both in AIA cases and for ex parte appeals. So I really, I don't know how many law students are out there, or people who are less than 7 years out of law school that are on the program, or even clients and senior practitioners. Well, I just wanted to make sure everybody knew about our LEAP program and took advantage of it if it makes sense for them.
So just quickly for all of us on the rest of us on the panel, I know we've all had some experience with the LEAP program with some of our associates. Can you guys just quickly give us your pros, your cons?
Yes, I'll just jump in and I'll say Judge Bonilla is completely on point. It has been very effective. I know our firm, I checked in, we've had 19 people go through the boot camp, and across the board, all of the associates have raved just about the ability to have that mock argument. And then we've had 4 individuals actually participate through the LEAP program in an actual oral argument. I know I had one oral argument where I had a LEAP practitioner, and he did a great job. The judges noted it, recognized it, and appreciated that attorney having that ability. So I see nothing but pros there, and I haven't had any negative experience thus far.
Oh, I'll speak from a lack of experience only in the respect of mentioning the concern that Judge Bonilla expressed a moment ago, and that is you have to convince the clients that this is a good deal. You have a bet the company case, and they're expecting, they came to lead counsel for whatever purpose, and they expect lead counsel to carry the ball. But have been successful, not with a practitioner that would qualify under LEAP, but nonetheless a young partner, do the entire argument. And as the judge explained, some of these folks know the record code, and he did a spectacular job. And so, you're kind of on the edge of your seat while this is going on, because, the proof doesn't come until the argument's over, yeah, and the client has been listening and, looking for scowls on the faces of the panel. But it takes you a while to get vindication for doing this, but in the end, it's worthwhile.
Right. And Brent, just I've used the LEAP program as well several times. And I think one of the ways I've used to get the clients comfortable is we've enhanced the moot courts we do prior to the oral argument, so that the young attorneys have more aggressive moots, 3 or 4 leading up. So the client gets comfortable that the attorney is comfortable presenting an argument and comfortable handling really tough questions. Because I will tell you, the PTAB judges ask us really tough questions, and you have to be prepared. So I think the moot courts really help get the attorneys comfortable, the younger attorneys, and the clients comfortable that everybody can handle the argument when it comes.
Great. So we have, using Adam's clock that I'm looking at, we have about 5.5 minutes left. I want to make a formal pitch for Q&A. I know a few people have been good enough to provide some questions during our conversation. I don't see anything in the Q&A panel right now, and I don't want to give up any time, right? I mean, you've got 14,000 words. You're going to use them all, or as close as you can. So we got 5 minutes. So if I don't want to have dead space, and we have another topic that was kind of like if we have time, and so I'm going to go ahead and jump into that. But feel free, all of you in the audience, and there's 66 of you. If there's an issue that we didn't hit, we're probably not going to hit Arthrex, we know about it. Don't say, why did they even talk about Arthrex? It's like, yeah, we know it's the 600-pound elephant in the room or whatever it is. But Judge Bonilla, that's not really something she can talk about. We're not gonna talk about estoppel, because Synqor and Minerva are pending, and so we've kind of decided those are probably best left for a panel without a PTAB judge sitting. But here's a question. Judge, I don't know if you can see it, but it's to you. Have any more experienced attorneys spoken up to cover a leap mistake during oral argument?
I have to be honest with you, I have literally never seen it. It may have happened and maybe I didn't know about it, but I have not seen that. My experience is that they have done a phenomenal job. So that over-prepared is what I would talk. I mean, think about it from a junior. This is a big deal for them because they get a chance to argue, and then they can say they've argued before. This is sort of the path to being able to argue a lot more. So my experience is that they are super prepared. Judge,
maybe the better question is: have you seen senior guys flub it and have to get fixed? have to get it fixed by the attorney, the younger attorney sitting at counsel table, giving them the elbow or passing the post and saying, and then the senior guy going or senior gal going, "Oh, let me fix that."
It's funny. I probably have seen that more often. I'm being a little funny, but I mean, truthfully, people aren't perfect. You're up there. We know you're nervous. It's a high pressure situation. And sometimes you don't have it perfectly. We're not there to trip you up and mess you up. We really do want to get the answer to our questions. I mean, one of the things that's sort of great about PTAB, I guess you can debate with this, I guess, but there's no jury, right? We just want to get to the answer to the questions. We're pretty sophisticated on patent law and on the technology, so we don't care how slick you are, right? As long as you can answer our questions. So we are cognizant of the fact that somebody might misstate something or they might need to clarify the record later. That's okay. We don't use that against somebody. So if somebody says something and they have to go to their co-counsel and they furiously are writing a note to clarify something, and oftentimes you don't know the answer. And your co-counsel will give you a hint of what that is. So we do see that a lot, and that's not a bad thing when that happens.
Okay. So great question. We've got a couple more minutes, and just so again, is that we don't leave anything on the table, and Adam's not pulling me off the podium here. Mm-hmm. Judge, give us two minutes to tell us about the MTA, the motion to amend pilot. I know you were out on the rubber chicken circuit a couple years ago, telling everybody about the MTA and how it works and all that. So you've got a couple minutes. How's it going? And are we seeing more MTAs? And are we getting more claims through?
Yeah, so just to remind everybody who doesn't know what the motion to amend pilot is, this is something that we started a year ago last March. And it basically gives patent owners in an AIA proceeding two options they didn't have before. They don't have to take advantage of them, but they're options if they wish. The first one is they can request preliminary guidance from the board. So after they filed their motion to amend and after the petitioner has filed an opposition, the board will provide preliminary guidance on what they think so far. It's preliminary, it's not binding, they can change their mind later, it's based on a preliminary record at that point. But it can be really useful information for the patent owner because at that point they have a choice. They can either file a reply to the opposition if they want, or they can file a revised motion to amend. So for example, if they realize from the preliminary guidance or even from the opposition from the other side, it's like, ooh, you're right, there's a problem, but I know how to fix it. I know how to amend the claims to get where I need to be. They can do that in a revised motion to amend, and then there's an opposition and a reply and a surreply there. So those are the two options that people have. And what we've seen so far, so we're about a year in, and what we've seen so far is that the percent of patent owners that choose to file a motion to amend, it hasn't really changed. It was about 10% of patent owners in instituted trials before, and it's about the same now, about 10%. So a lot of people aren't necessarily filing motions to amend, and there are lots of reasons for that. From a strategy standpoint, there's intervening rights and things like that. They may not want to, but when they do file them, I will say, as of the end of March, we had a little over 120 motions to amend that were filed that qualified under the pilot. And so far, we've decided 64 final written decisions that address a motion to amend on the merits that qualified under the pilot. And what we've seen is that patent owners are electing the motion to amend pilot, at least one of the options in the vast majority of cases. And the bottom line is that for patent owners that have chosen to take advantage of the pilot, they were more likely to have their motion to amend granted with at least one substitute claim. So, for example, prior to the pilot, about 14% of the motions to amend were getting granted. Now today, overall, it's closer to 23%. And I would just point out that if patent owners have taken advantage of the pilot, about 26% of those motions to amend were granted or granted apart. So that's quite a bit of an improvement there on behalf of patent owners. And in the case where they have not taken advantage of it, 9% of them were granted. So it does seem to make a big difference about whether they take advantage of the pilot. And that makes sense because they get information and they can sort of maneuver and take advantage of that. So we would just tell people, keep in mind that option, keep in mind the option of reissue and reexam. As I mentioned before, you can do this before, during, and even after a final written decision. There are options to amend claims depending on what's going on in the case.
That's really helpful. That update helps. And here comes the hook as we were expecting. Hi, Adam. I just want to say quickly, Judge, thanks so much for taking your time, and thanks to the board for helping us out. Herb, Lori, Kent, Leston, great discussion. Thanks so much for joining us. Adam, back to you.
Thank you, Brent. And I'd say it's more of a gentle nudge than a hook. But yeah. So thank you to our panelists, echoing everything and Brent, everything Brent said. We greatly appreciate your participation here, and this was a very insightful panel. And I'm hoping everyone else enjoyed it as much as I did, actually. So what we're going to do now is we're going to take a short break while we get ready for our second panel of the day. So I will see you back here in about 15 minutes. Bye, buddy.
Bye, everyone.
All right. Welcome back, everyone. I hope you had plenty of time to catch up or track down anybody you needed to or felt like it. Now we will be introducing our second panel. That will be our district court practice panel. It'll be moderated by Ken Adamo. And as we get people up to the stage, oh, looks like people are beating me to it. Look at that. Okay, let's see. So Ken, welcome. Looks like waiting on one more. Absolutely. All right. Welcome to our panelists. And Ken, go ahead, take it away.
Well, good morning. We have a lot of things to talk about, I hope, directed to district court practice, and I've got a great panel, starting with Judge Chang. Edmund Chang is a district court judge here in the Northern District of Illinois, and I'm also joined by two trial lawyers, not two litigators, two trial lawyers. Elaine Herman Blaze from Goodwin Proctor in Massachusetts, and Karen Jacobs from Morris Nichols in the District of Delaware. Now, we didn't plan it necessarily this way, but I actually spend a lot of time in the Eastern District of Texas. Elaine is from Massachusetts. Karen is from Delaware, and His Honor is from Northern Illinois. So we have, of those districts, Eastern Texas has patent rules, District of Massachusetts has patent rules, Northern Illinois has patent rules, and Delaware doesn't. So Karen is going to be picked on quite often here to explain why, in view of the high filing rate that Delaware has always enjoyed, why Delaware doesn't have patent rules. We're not going to try to address everything in a district court patent proceeding from soup to nuts because there just isn't enough time. We're going to stay fairly close to the general topics that are in the announcement document. I guess we officially called it the Masterclass Virtual Seminar document as we go through things. So that means essentially that we're going to start with pleadings and end up with jury issues. So let's start. Your Honor, seeing you're the one judicial officer in this interesting group of people, I thought we'd be good to start with you, particularly since I've got your markup of our topics here that have what you want to say in boldface. So let's go. Let's get on with it. All district court cases begin with pleadings. Iqbal, Twombly standards have now permeated into almost every facet of district court pleading practice, at least, and the level of detail that's required, et cetera. Alice motions. I know you wanted to address Alice motions particularly. By an Alice motion, I would mean a 12B6, a 12C, possibly a 12E motion, very early on, trying to challenge or to effectively get a dismissal of a case based on Alice and Section 101 practice. What has been your experience with that, Your Honor, and how do you tend to handle those motions?
Yeah, sure. I mean, and let me address, both kind of sets. I think in terms of the Twombly-Iqbal motions, there was that kind of rush after Iqbal in particular, where I would see quite a few 12B6 motions, and they seemed to me like kind of like chucking up a Hail Mary, at the end of a game type, like, well, maybe the judge will think that there's just not enough, concrete factual detail, and we can get rid of the case like from the very beginning. And over time, I think, at least in the practice in front of me, has reached kind of a happy equilibrium where, well, I say happy because I don't see as many of these motions now. So I guess it's a happy equilibrium from the judicial perspective. I don't see as many of these 12B6 Hail Mary motions anymore. And I think over time, what happened is the complaints did get more, factually detailed. There was a bit more concrete information. I got the sense that I was seeing something like a cease and desist letter, like cut and paste into a complaint. And I think that was, enough. Most defendants, I think, just kind of retreated at that point. And I have not seen as many of those 12B6 motions. On Alice motions, so, those are fascinating always because you are asking right from the threshold, is there some just abstract concept or law of nature that can't be patented? And I recognize an early 12C motion, and I think certainly in our circuit, it's a 12C instead of a 12B6 because it's an affirmative defense. So it really should be brought under 12C. The balance that we're trying to strike is it is just the pleading stage. All right, I recognize that, and I understand plaintiffs are in tight spots because later on at claim construction, they might very well want to say that, look, plain and ordinary meaning, right? And that it kind of becomes a little bit of a trap for the plaintiff, where the defendant says, bringing an early Alice motion, we don't need, claim construction. If you take the plain and ordinary meaning, this is invalid. And I think plaintiffs can be in a little bit of a tight spot. But sometimes factual development is needed, and certainly for judges who have to view the claims through the lens of the skilled artisan, like we might not be able to do that. Like plain and ordinary meaning viewed through the lens of a skilled artisan might not be something we can suss out at the pleading stage. But having said that, I have granted, an Alice motion early on where after reviewing the claims, I thought this really is just directed at a very abstract data collection, storage, recognition problem, and it's not doing anything new with it. So it is a balance that has to be struck when we get those early 12C motions.
Elaine and Karen. Elaine, for those of you who don't know, I guess specializes, is that fair to say, Elaine and ANDA, BPCIA types of matters, is that fair?
I would say it's one of my specialties. It does tend to be a large portion of my practice, but it's not exclusive.
Sure.
Okay. And Karen, you've done everything. That's fair.
That's right. Yeah.
Okay. What are you two seeing in use of 101 motions, and particularly, are you seeing what I think people are starting to see is pushback from judicial officers on these early 101 motions, where if brought under as a 12C, the defendant trying to kill the case early on is not trying to tell the judicial officer we need claim construction, et cetera. And I think what Judge Chang explained, it's the flavor of the month because they tend to work. But I'm seeing a lot more reluctance on the part of judicial officers to just grant one and not go through the analysis of the things the way Judge Chang has, where, hey, sometimes you have to have a markman, sometimes this, sometimes that. What are you two seeing?
So I don't see them very often in the sort of pharma biotech space, but when I've had tech cases, it really depends on the jurisdiction, I think, quite heavily. And maybe the most recent interesting experience I had a case that was filed in ED Texas. And so we thought, probably not going to file a 101, but then it got assigned to Judge Bryson by designation. And so we did file the motion, which was very interesting, having sort of this district court 101 argument in the federal circuit in front of the judge. My memory is there, it ended up settling as a result of, I think, the plaintiff feeling like they got a little bait and switch when they filed in ED Texas and ended up with Judge Bryson. But I think it's very jurisdiction dependent in my experience.
Karen?
And what I'll say, and I'll do my plug for the Delaware way in terms of not a fixed rule on this, is 101 motions are it really is a case-by-case basis. Some cases cry out for early disposition. And Berkheimer and Atrix, I know they're often cited for there's always fact issues and you should always delay a 101 motion. That's not what the cases say. They point out that there can be reasons why there's a need for factual development. But in some cases, the deficiency is pretty clear on the face of the patent, where the patent itself refers to its technology as conventional. And so it's it's a little bit of work on the front end to figure out which are the cases that really can and should be decided early on, and which ones really do need factual development. And in our court in Delaware, several of our judges have 101 day, and they have a 101 checklist. And some of the questions that you have to answer in that checklist is, are there issues of claim construction? Should this wait for claim construction?
This is something that Chief Judge Stark set up, right? He's the one who has 101 day.
He started it, but other judges are also doing it as well. And they may hear 3 or 4 motions, and they're not all granted. I mean, I think there's sort of a perception of, well, this must mean that the court's trying to take them all out, but it's really not. It's trying to figure out which are the cases that really are appropriate to decide right at the pleading stage. Is there really a claim construction issue? Is there really some factual development that's needed? And the checklist includes, it asks both sides to fill it out in terms of, are there claim construction issues? What is the factual development that may be needed? And what are the cases that you contend yours is closest to, both from the plaintiff and the defendant side? Because very often 101 motions very often the court looks to what's the closest analogy.
One of the things that this discussion we just had points out to me, choosing where as a plaintiff you file a lawsuit is always important. I think that it's probably more important in a patent case than it is almost everywhere else. And I'll give you a couple of quick for instances. And Judge Chang, you don't agree with anything I'm saying here. You fix this. Eastern District of Texas. Well, if you had done your homework on Eastern District of Texas, you'd know that Judge Bryson is down there all the time. He's practically on the wheel. So you have And you absolutely have a great chance to get Judge Bryson if you hit East Texas. So going to East Texas, there are other benefits, but one of the things is you might get not only Chief Judge Gilstrap and some of the other excellent judicial officers down there, but you might get Judge Bryson. That's a matter of doing your homework. Local rules, who has them and what do they say? Look at who we have on the screen. You want Northern Illinois local patent rules? Those are different than Massachusetts and East Texas. And there are some advantages to Northern Illinois. You want a district where traditionally everything gets argued, right? You get up on your hind feet, whether you're doing it virtually from here on out or not. You go to Northern Illinois, or you go to East Texas, or you go to Delaware, or maybe even you go to Massachusetts. Looking at 101, I think, is a prime area, though, that right now you should be trying to figure out which district you're going in, because the judicial officers, some of them are handling it the way Judge Chang did. Others are handling it differently, and you are starting to see some momentum that some districts seem to be coalescing about the fact that maybe 12C is not correct in all instances here. We do have to pay more attention to the claim construction, et cetera. So I think this is a good example of how district court practice really does require doing a lot of your homework. That sound fair, Judge Chang?
Yeah, I mean, it does. I think that kind of, I suppose in some ways it should be disconcerting to the bar that when the point of having the federal circuit was to try to nationalize patent law to some extent, and so that maybe it's disconcerting to the bar in that respect. I think the flip side view of that is that maybe it's this kind of local variation. It's not a bug, it's a feature, right? Like we generally do, at least the traditional view had been from the Supreme Court, that if you get localized variation kind of experiments from different districts and then also circuits, different answers to different questions, then ultimately you get to a more accurate, or in this case, in this situation, a just like more substantively fair, procedure. If you have a lot of different approaches. I mean, I think at some point you then want to settle on kind of an answer, nationally. So I think that it also permeates affirmative defenses too, like how much you have to say about affirmative defenses. I mean, there is a deep district court split all over the country, as well as a mild circuit split on like, well, how detailed do you have to be on affirmative defenses? And it's another way to bog down a case, to start bickering about, well, did you put enough detail about your affirmative defenses in the defendant's pleading? I think you're absolutely right that there is this massive variation. I will make a mild defense of it for some period of time, and then the bar does deserve a national answer on most things.
Well, I think what this points out, at least to some extent, is you forum shopping, if you're representing a plaintiff, is actually, I've always thought, one of the things that a trial lawyer is supposed to do. And a potential defendant who can bring a declaratory judgment action, not always, but most times, they're supposed to be doing the same thing. My point here is this is the way the system operates right now, and I think that we all need to be aware of this. And whether you're on the left side of the V or the right side of the V, you should be making these choices. Now, Your Honor, I'm not going to mention who it is. There was a judicial officer in the Northern District of Illinois who, for a while, if I'm recalling it correctly, not only did not like invalid under Title 35, including 101, 102, 103, 104, and took a lot of action based on that. But also, if I'm recalling it correctly, was of the view that you should not both file affirmative defenses and declaratory judgment counterclaims raising essentially the same subject matter. So again, here's an instance where if you know that's the predilection, you can make that kind of choice. All right, we're going to move on. Your Honor, I've got a note here that said you particularly would like to talk about standing orders in which Northern Illinois promises more senior lawyers, et cetera, et cetera, et cetera. And Judge Bonilla just made an amazing presentation in the PTAB portion of the LEAP program, and boy, she was selling it. She was selling it hard, and everybody was going, "Yeah, that's fabulous," and it is. So, what's Northern Illinois doing that's like that, where you're trying to get the younger people up on their feet?
Right, and it's so it's not uniform across all the judges. It's just that I think probably two handfuls of us have adopted standing orders in which we are trying to encourage newer attorneys to be able to have important speaking roles during evidentiary hearings, claim construction, and trial, because we do see them, kind of languishing at the table, and they have probably as much, and I think Judge Bonilla mentioned this, I caught a little bit of that last presentation, as much or more, knowledge about the case law, about the facts, the factual record than the senior partner who's actually arguing and presenting. And you also see that when they're handing notes to the partner, like throughout the hearings. And so, yeah, I mean, you're just kind of thinking like, you ought to give them the opportunity. I mean, there is an enormous, problem in terms of in private practice and really any legal organization in retaining, diverse attorneys, attorneys of color and women. And so I think giving them those speaking opportunities to impress the client and also just get excited, about being in the courtroom and standing up and arguing is very important. So the standing order encourages that, and then it makes the promise that we're not going to impose any kind of one lawyer, per issue, or one lawyer even per witness kind of argument or examination, right? And so you should feel comfortable if you think that, you as the more senior lawyer, if you need a parachute in, on a rescue operation to answer a question, you can come on up, and that's perfectly fine. And continue the argument or ask some additional questions, or answer a question that I've posed during claim construction hearing. And I will say, I think my experience has been a little bit different from Judge Bonilla. I think she said that she hasn't seen that that's been necessary, like the senior partners haven't. So I kind of seen the opposite, where they do tend to come up. And now, whether they actually add anything or not is a different question, but they do, I think, come up when they feel like it, and like, again, perfectly receptive, not keeping a strict clock on the argument either, because we do think it's important. And so it's not a local rule, but it is something that, I think close to half of us have adopted.
That sounded vaguely like age discrimination to me, Your Honor. But I'm just sitting here trying to be quiet.
That's why I said newer attorneys early on.
Can I weigh on this really quickly? Because I'm a huge supporter of this, and I've seen this in the District of Massachusetts. Judge Burroughs has made very clear that she really wants to give less experienced or underrepresented attorneys chances to speak. And we've had great experiences, for example, taking on a pro bono jury trial where one of our most junior IP partners was lead counsel, and he staffed that case with a team of associates who all got witnesses. And she actually instructed the jury at the beginning that she had asked our firm to take this case on pro bono, and that they were going to see lawyers who were doing some things for the first time, and they should enjoy the experience of seeing that happen. It was a wonderful way to sort of tee it up.
Christmas, you got Christmas came early that day, huh?
Correct. Just wonderful. Yeah, just wonderful. And then Judge Andrews, sorry, Karen, I was going to say my experience. Judge Andrews has been great in Delaware with junior people taking their first witness or doing claim construction.
Yeah, and Elena, I was just going to add to that certainly some of our judges have formal orders on incorporating or bringing in younger or newer, I should say, attorneys. But what I always like to remind people too is even if I'm before a judge who doesn't have a standing order, I think like what Elaine is saying, I always like to introduce or say, this is so-and-so's first Markman hearing, or this is so-and-so's first. And you know, the room just lightens up. I think everybody is rooting for that attorney, whether, because I think that everyone appreciates hearing that. And it's good to let people know that this is somebody's first argument. And usually they do a fabulous job. Yeah. But it could put a little gloss too if someone's feeling nervous. It explains why they're nervous. And like I say, I just kind of regularly do that, whether there's a standing order in place or not. I just think the court and appreciates knowing and that someone's having that opportunity.
Yeah, and Karen, that's a great.
And gave me my first witnesses. Let's just throw Ken a bone and say he gave me my first witnesses.
Yeah, I mean, I think Karen makes a good point about letting the judge know too, because I have allowed claim construction arguments to go on, you know, probably longer than I would have had I not known that. Where I've kind of got my questions lined up, you know, so I was like, okay, I think I could just kind of get to the heart of the matter with questions 1, 2, 3 here. But if I hear that, I will let the attorney just, you know, present for much longer than I normally would before interrupting, so that they get that experience. I'm not quite. There are some standing orders that, you know, and heaven bless them, you know, some judges will say like, I won't have oral argument unless it's a new attorney. I'm not quite there yet on really forcing the client to, you know, to decide something like that, but I will allow more time and just more uninterrupted argument.
All right, I want to transition off into something else now, but this discussion that we've just had is another instance where you need to do your homework to find out whether you're a plaintiff patent owner or you're a defendant bringing a DJ action. You've got to find out what the practice is in the various districts, because there are so many of these programs, and these for not only for teaching purposes for the younger members of the bar, but you know, just for tactical reasons, you've got to be able to take all this into consideration. Let's talk a little bit about stay motions and the interface of district courts with the AIA post-grant proceedings. If you're the accused infringer, your toolbox almost always says, "Quick, file an IPR and let's move for a stay." Have you had much experience with that, Judge Chang? And if so, what's your normal reaction to how you handle those motions?
Yeah, a few times. I mean, not as recently, but certainly if IPR has been granted. Given the success rate, although, you know, maybe that's changed over the last year, I haven't seen one of these in a while. I'd be interested to see what the dashboard now says in terms of success rate in front of the PTAB. But given what, you know, when I had looked at the dashboard, the success rate in either outright eliminating or narrowing the claims at least, and given the time limit on the PTAB, you know, to issue decisions, it does make a lot of sense in my mind if it's been instituted to just hold off and get the expertise of the PTAB and the benefit of that. And then after the SAS decision, then it's like, oh, okay, they're going to address everything, you know. So it's we're going to get an answer pretty much on everything. So that's you know, really helpful. If it hasn't been instituted yet, it's just that the, you know, petition has been filed. I mean, those are a lot harder. I think I usually like to see the petition itself and the response of the patentee. And but you know, it's so early on in the case. Typically, I don't. It is very much a crapshoot. And so I'll listen to arguments about how burdensome discovery would be, how one-sided it might be, and that'll factor into the decision making. But there are times where, you know, you read the petition and like, this seems like it is either very strong or very weak. So yeah, those are all the things I'm balancing.
Karen, in our prep materials, you contributed on this subject that we should discuss the Goldilocks syndrome. When is a motion too early and when is a motion too late? Why don't you tell us about the Goldilocks syndrome?
Yeah, well, of course, as we all know, a motion for a stay is a multi-factored analysis, very fact-based. But certainly one of the factors is how is it going to impact the timing of the case? In the ideal world, you want to bring a motion to stay early so that you can say there's going to be some real savings here. That if you grant the motion to stay, everyone's going to save resources and expense. But on the other hand, a lot of courts are really hesitant to grant a stay until there's at the very least an institution decision. So by necessity, and maybe you need to wait until there's been some infringement contentions to know what claims are in play to even know what IPR petition to bring. So there's some delay sort of inherent in the process if you have a judge who wants to wait for an IPR decision, and most do. There can be some instances where the mere filing of a petition is enough, but that's a much tougher sell than if there's been an institution decision. But by the time you wait for infringement contentions and then the filing of a petition and then for the PTAB to act, you may be a year into the case or more. And now have you now flipped in a way that too much has gone on and there's not enough savings in terms of what has to happen in the case yet? And that it's tough. And that's, one of the things we've looked at is you really have to, if you really are going to go for the stay, really try to get that IPR on file just as soon as you can. And even let the court know at the beginning of the case, we file these IPRs. We know that the court may not want to hear a stay motion from us until there's been an institution decision, but Judge, we just want to let you know it's coming. And maybe we bring that up in our Rule 16 conference, even as we've started down this path and we want to let the judge know about it. So that's the Goldilocks issue I'm talking about, is on the one hand, you got to wait. On the other hand, you want to do it early.
Elaine, your experience in this area, but more particularly because when you're doing ANDA work, you also are dealing with the magic 30 months. So would you talk about that a little bit? And then how does that intertwine with stay practice in your experience?
Sure, it's interesting. So I worked on the patent reform for the generic drug industry. And I sort of thought, this IPR thing, it's not going to get used much in the Hatch-Waxman context because of the 30-month stay and because of the possibility that the decision from the patent office, from the PTAB, wouldn't give you kind of the certainty you needed. I didn't think it would be used much. And we're not seeing it used that much in the Hatch-Waxman context, but we're seeing it used extensively in the biosimilars context. And there, I think it's very interesting. You have a slightly different Goldilocks problem, which is if you file too early, you might not have standing when you need to go up on appeal. And so that timing issue becomes different than what we're dealing with the district court, right? Because in the biosimilars context, you're doing an FTO very early. You're thinking about, are there patents you could try to clear through the PTAB? And then you don't want to do it so early that if you lose, you can't appeal. And you have to stack that up against when you expect your BLA to be filed, when you expect it to be accepted, when you expect it to be approved, when you expect litigation to take place. So again, that Goldilocks too soon, too late question has other complications in that context.
An interesting practice that was used and still is used in Eastern Texas. Judge Folsom, when he was on the bench, started it, and Chief Judge Gilstrap grabbed onto it. IPRs, of course, can be brought by a third party, not necessarily the plaintiff or the defendant in the case, which actually can be very advantageous because if the third party brings it, nobody gets stopped who's involved in the case, at least theoretically. Judges quickly figured that out and started asking people, well, if I give you the stay based on this IPR that was filed by this other party, I don't get any savings down the road, right? If things happen in that IPR, I don't get my docket doesn't get one case lighter because you're not going to get a stop by this thing. Isn't that correct? And you'd look at the floor and you'd look at the ceiling. And of course you'd say, well, yes, Your Honor. Well, okay. So here's the deal. You want to stay? You're going to agree to be bound by whatever happens for estoppel purposes on that third party IPR. And I tried several times in front of Chief Judge Gilstrap to try to convince him that that was not really fair because the system was set up to do it another way. And he sort of just looked at me and he said, this is really simple. Do you want to stay or not? Right? If you want to stay, you're going to take my deal. If you don't, it's discretion. What are you going to do? Take me to the circuit on mandamus? Although these days you got to watch that because the circuit takes mandamus on strange things. All right. In any event, that's something that you have to worry about. Okay. Local counsel. I know we talked about this in prep. We said, maybe we shouldn't talk about it. We ought to talk about local counsel. Karen, why don't you talk about local counsel first? Because Delaware has got, a very particular view of local counsel.
Yes.
Which is good in my view.
Yeah, thank you. Yeah, I mean, Delaware has a very active role for we call ourselves Delaware Counsel because it's a very busy court. The court has a very high patent caseload, as I'm sure many of you are aware. And the court expects Delaware Counsel to be heavily involved, both because you rely heavily on the Delaware Counsel to know not just the court's preferences, which are available on the website. You can look up the preferences there, but there's a whole body of of discovery disputes, for example. There's not a lot of written decisions on discovery disputes. They're often handled on telephone conferences that your only record is a transcript. The court often has, pretty fixed views on how certain disputes should be handled. And the court also really looks to Delaware Counsel not only to make sure things go smoothly in terms of, that motions and hearings are presented properly according to the court's expectations, but expects us to get involved to make sure that we're really getting to the heart of the dispute. And a couple of years ago, the court actually amended its local rule on meet and confers to require the participation of Delaware Counsel, both a verbal meet and confer and including Delaware Counsel before you can bring a dispute to the court, because often our involvement really can resolve a dispute and say, look, we've been there before. We know how the judge has handled these kinds of disputes. And and so sometimes we're helpful in resolving or at least narrowing the dispute. And frankly, I think there's a feeling too that we bring the Delaware way to disputes as well. We're a very small knit bar. The people that I'm with the other side of the V, we all get along. We need to get along because we're there all the time. And sometimes when things can get heated in a case, having that local connection can be very helpful in terms of breaking through a logjam, because we all work together on a regular basis. And the court really relies on Delaware Counsel to keep things running smoothly and to make sure that the disputes that are being presented are disputes that really need to be presented.
So far, we've got the Goldilocks syndrome out of Delaware, and now the Kumbaya local counsel approach. We're making progress. Elaine, what's the Massachusetts approach?
So it's interesting.
For Massachusetts counsel, Karen just slapped me because I know right. better than to talk about local counsel with her. I know you're supposed to refer to them as Delaware counsel.
Yeah. So it's interesting, Ken, because I am in Massachusetts, and I feel like our cases tend to be litigated more often by counsel that is resident in Massachusetts. And where I deal with local counsel more is when I'm going to Delaware, New Jersey, Texas, Pittsburgh, wherever it is. Cases that I have had in Massachusetts have generally had a big Massachusetts patent firm on the other side of them. So my experience has been more in the other locations, where I agree with Karen. I think the Delaware bar is very strong, but it also does matter who you have as local counsel in Delaware. And my experience is some firms are sort of better fit for different judges. They might have a little bit more insight on a particular judge. So we often think about that when our case gets filed, especially where we're the defendant, and we think, well, which firm is best with this judge in our experience? Because that can matter as well.
Judge Chang, I have in my notes here that this is another area where you wanted to say a few things about local counsel, please.
Well, yeah, I think there's the local counsel that's mandated by our local rule, and that is to be distinguished from the local counsel that I think that Karen and Lane have discussed. Our rule actually requires that you hire someone who is a member of our bar, and they tend to be resident in the Northern District of Illinois. But it is a decades-old rule based on the fact that we wanted someone, if we mailed out, as we used to do, orders, that they would receive it within a business day or two, and then they can pick up the phone and tell the out-of-state counsel what the decision was, or what the briefing schedule was, or whatever else it was. And it's just, to me, it's kind of just a vestigial, a leftover of the time when we did not have electronic distribution of notices. So that's kind of the bare minimum, which I don't myself try to enforce that. And when I have asked to waive it, I often will waive it. But when you get deeper into the case, and when you're talking about discovery disputes, or you're getting to the Markman or certainly trial, then it is really important to have local counsel who is familiar with the judge's unwritten, practice. Like I think we try to memorialize as much as we can out of transparency and fairness and access our practices, but it's just impossible to do. And there are just things that we don't think about that have become these unwritten practices. And so in those instances, local counsel are indeed invaluable.
One of the things that many people may not appreciate, because it's unusual, the Northern District of Illinois has a trial bar, does it not, Your Honor?
Yeah, so this was started way back when I think it was Chief Justice Warren Burger came back from England, and he started kind of espousing this idea of having like barristers, like members, like special lawyers who are especially equipped to try cases and put on witnesses and so on. And so our district, again, decades ago, decided that we would have a requirement that you be a member of the trial bar in order to present witnesses. And the idea would be to promote just better examinations, better trials and hearings. And so you have to have a certain level of experience to become a member of the trial bar. And over time, we have watered down, some of those requirements in recognition of the fact that it's harder and harder, to get into court and get these experiences. And we certainly don't want to, as you heard before, we want to go the opposite way to encourage, newer attorneys to participate. But you do have to be a member of the trial bar in order to actually put on witnesses in our court.
One of the things that I always try to explain to people about local counsel, you've all three touched on, but maybe I can summarize it, right? You don't practice in a district every day. You're not over in the courthouse. I like to pick a local counsel, and I actually almost got sideways with the best local counsel that I used at the time in East Texas, because I got quoted by the American lawyer referring to this person. I like a local counsel that I call a courthouse rat. Now, that is not a negative term. What it meant, this is Elaine and Karen will go, oh God, it's Ken talk time. Poor Judge Chang's mind, he's going to duck under the table or something. A courthouse rat is somebody who's in the courthouse every day, who knows the judicial officers, who's usually not a patent specialist, who's a really good stand-up general lawyer, because the invaluable thing that a local counsel gives you is the local counsel knows the judges. They see each other at bar events. They know the judges. They know the courtroom deputies. They know the local rules. They know the local patent rules. They know the standing orders. And then they know the real local rules, which is how the particular judge runs his or her courtroom. I think any trial lawyer who doesn't approach an important, any case, but certainly a major case, having not done their homework and gone out and gotten that type of a local counsel is, the type of people that maybe ought to be thinking about keeping their malpractice carrier's number on speed dial, which alas, of course, never wants to hear, because you just miss so much if you don't take advantage.
Yeah, I can, and if I could just jump in with the converse of this, which is that I hope lawyers recognize that judges are super gossipy. All right, like it's one of the most surprising things about the bench. Before I joined, I clerked on this very court, and I had a little bit of a sense, that judges talk to each other about lawyers. And then I practiced as assistant U.S. attorney for 11 years in this very courthouse. I was not prepared for the level of gossipness at coffees, lunches, when we see each other in the hallway, just in the lobby. Like, so what do you got going on? Oh, I've got this trial's going on. All right, and who are the lawyers? And that's always asked. And so there's a download of information about it. And then sometimes, like early on, when I joined the bench, I would get like explicit warnings, about certain lawyers. And so we are super gossipy. And I think the takeaway that you should have from that is, even if you have not appeared before me, if you've burned your credibility in front of one of my colleagues, I'm likely to have heard about that. And especially in this day and age where, I've got my bench laptop, I'm taking notes during status hearings, and I'll make a note like obstinate, like unreasonable argument. And it's like that Seinfeld episode where, Elaine went to the doctor and she like tried to sneak a look at her medical records, and then like he wrote something in secret in there, and then it got worse and worse, but he passed it along to the other doctors, and that's what we do as judges. So even though there's 22 active judges on the district court, and you think 1 in 22 chance I'll ever see this judge again, no, I will hear about you. So that's just kind of the converse of the courthouse rat.
I was instructed by someone once that you've got to understand that the federal courthouse, state courthouses was the context, but federal courthouses, of course, are all the same way. They're a family. And from the moment you walk into the building and go through the magnetometer or whatever, everybody in the building knows, oh, there's some new person down there. And the guy had a solid gold Rolex on. Can you hear that? The court security officers are calling everybody up in chambers, say, hey, this guy's coming up to see such and such. I swear to God, he's got a gold watch on. And people come out in the hallway, etc. So yes, you definitely have to understand that you're in that type of environment, and there's where a good local counsel can really pay dividends. Because if you've got an acerbic personality, you've got a non-Delaware friendly personality, your local counsel can act as a buffer, and it can make a huge, huge difference. All right, early summary judgment practice. We talked about this in our prep. Many of the local rules, and not just local patent rules, but local rules say, here's when you can bring summary judgments, right? You get the scheduling order, and it's got everything spaced out, and summary judgments are usually, in a patent case, somewhere after the Markmans and somewhere before we start really getting trial ready. Early summary judgment motions now have, in my experience, have become more of a thing that people try for. You got any views on that, Your Honor, about early summary judgment practice? Because I think your local rules here in the Northern District pretty much don't like early summary judgment practice, if I'm remembering them correctly.
Right.
What's your...
And that's definitely...
If I'm remembering it correctly.
You are remembering it correctly, and that's reflective of our general attitude. Like, don't like them. We don't like them, and there's a couple of reasons for that. I mean, one is that typically it's early for a reason. Right? Like often we need all of the discovery to have concluded in order to have a summary judgment motion where you don't get the 56D response saying, well, wait, we don't have this piece of information or this piece of information, and so it's a waste of time. And so our local patent rules, the default is that you have to conclude all of this discovery and also the claim construction too, as well, before you bring a summary judgment motion. There's always exceptions. You can always ask, for good cause to bring an early summary judgment motion, but it will take a lot of convincing because I think of our general experience that it's not ready to go at that point. Second, even if it is ready to go on a particular issue, what we're fearful of is that unless, again, it's really obvious, absent that scenario, the concern is if I deny the summary judgment motion, I'm going to have to relearn this case again, in another 9 months after discovery, claim construction. And here we go, with a second round of summary judgment motions on the same case. So yeah, candidly, it's a conservation of our time and resources, even if the dispute might be teed up and ready for a decision on that. Now, if you want to convince judges that an early summary judgment motion is, that we should take that up, if it's really going to impact settlement, right? And this is where credibility again, comes up. Like if you're a lawyer who's got a track record of credibility with me, and you represent to me that, look, if you can just give us an answer on this early summary judgment motion, I promise you that's really going to dictate how we go on settlement negotiations. I'll think long and hard about that kind of that scenario where we may just very well resolve the case, even if the summary judgment motion is denied.
See, another good reason to have a local counsel. You have your local counsel do that, so he or she is the one who's got the skin in the game, who had to make that promise to you. So you got a little bit of a buffer in there. Karen, Delaware, do your judges go nuts when someone comes in with an early summary judgment motion?
Well,
metaphorically.
Yeah, like Judge Chang is saying, it's in each of our judges' standing orders, the expectation is that summary judgment will come at the end of the case. That being said, it's something that, for example, with Judge Stark's checklist, it's something you are supposed to discuss at the front of the case. And in a rare case, it may be that there's one claim construction term, that if it's construed a certain way, it's going to resolve the case, for one side or the other. Or maybe there's, some unique issue that really doesn't involve development of facts. Maybe it's an indefiniteness issue. It's a rare thing, but it does happen. And I think, the court encourages the parties to discuss that. And as you're saying, Ken, you have to have a little credibility about it. You can't say, well, I like to take a shot at these issues then, but if I don't win, then I want. A busy court doesn't really want to hear that they get to do summary judgment twice unless there's really going to be a clear benefit, both in terms of there's not going to be fact issues, and so it's not a waste of anybody's time, but that it's worthwhile for the court and the parties' time, and that you want the parties to have some skin in the game, and that if Judge Robinson used to say she wouldn't do early summary judgment unless everyone agreed, and that's hard to get agreement too. But there are, it's not every case, but there are some cases where there's clearly, you can identify one or two issues that if you could really take on early, may resolve the case. And, depending on who the plaintiff is, often plaintiffs will recognize that they have that issue and sometimes join in wanting early resolution, because if they're not going to get out of the gate on that, then they don't want to put the resources in either. So it's not always a foregone conclusion that one party wants it and the other doesn't. And I have had instances where the parties have actually agreed to sort of take the core issue up front, so that they can get resolution from the court. But that's, understandably outside the norm, because otherwise you're going through summary judgment twice in the case. Very few parties are willing to say, I'll take my stab at summary judgment early on and I'll never bring a summary judgment motion again. That's,
Elaine, what's the Massachusetts experience in this area? And I guess not more to the point, but do you see much in ANDA BPCIA type cases? Do you see much attempt to do any early summary judgment or summary? I've seen summary judgments, but has anybody ever tried an early summary judgment in your experience?
So I had a case that was actually a Delaware case that got assigned to a judge in the Eastern District of Pennsylvania when I think Delaware was down a judge. And that was a case in which we thought we were the defendant, the only claim of infringement was doctrine of equivalence, and we thought we had a very strong prosecution history estoppel argument. So I went into the initial scheduling conference and told the judge that was our position, and we needed his advice on what motion to file and when. He allowed us to file an early motion for summary judgment. The plaintiff said, oh, we need discovery. And the judge said, you can have your discovery. And guess what? We're going to trial in 3 months. The case settled at that point, which was fine. But, I think this is a place where you need to know what you're asking for when you ask for this. So we were fine with that result in that case. But Judge Young in the District of Massachusetts, not necessarily in the summary judgment context, but if you came in and you said we need a preliminary injunction, he'd say, you know what, let's have a trial. Let's just try the case. And he would expedite it a lot. We're going to trial in 5 months kind of a thing. So I think you really need to know what you're asking for and also what your risk is. So I just had an experience, again, with Judge Burroughs in the District of Massachusetts, where the defendant insisted on arguing indefiniteness as part of the claim construction process. We told them we thought it was inappropriate. They did it anyway, and she granted summary judgment against them on indefiniteness as part of the claim construction order. So there's real risk when you do this early as well. I think people should keep in mind.
Before we transition into a next subject, while this is not summary judgment specific, but the concept of bifurcation. Everybody knows that there is the ability in the Federal Rules of Civil Procedure to try to get various things bifurcated. And Karen, you mentioned Judge Robinson at one point. She had a very interesting way to order her cases. As I recall it, the Markman and the summary judgment used to run in tandem, and they didn't come until the back almost of the end of the case, where you were virtually at the eve of trial, and that she always bifurcated damages. Am I remembering that correctly? Is what that used to be?
That was, although she did change her. She then changed.
That's where that's the rest of the story I want you to tell. And then Judge Chang, I've got a note here that you've got a bifurcation view that I think factors into this story that I'm getting Ms. Jacobs to tell.
Well, and I think this is an area where there has been a lot of development in the law and views on, on the one hand, I think when, as Ken was saying, when the court was more likely, Judge Robinson in particular, to bifurcate either to only having a certain number of patents addressed in a single trial or bifurcating, it was really to try to simplify things for the jury. But, there's also just the inherent prejudice of chopping up issues. And, I think where Judge Robinson, after, what the District of Delaware did, I guess it's probably about 10 years ago now, was really did a study of its procedures. And Judge Robinson and Judge Stark did many, many interviews to try to, sort of come up with best practices. And I think following that, sort of all the judges, certainly the default now is that there's going to be a single trial on all issues. Not to say that there can't be bifurcation in a particular case, but by and far, the far more typical thing is to do a single, quite short trial. I mean, it seems like our trials are getting shorter and shorter in terms of the time limits. Part of that is because we're a busy court, but part of it is, too, is that I think the court has just come of the view that the cases that are best presented are the ones that are succinct and where you really push the parties to put the, to synthesize their case. And I think the court has found that that's really the most effective presentation. So like I say, it's been an evolving thing, but I think it largely came out of that case study that the judges did on the District of Delaware. They sort of evolved to feeling that by and large, the non-bifurcation is probably, in most cases, the best way to go.
Elaine, again, with not your area of exclusivity, but your area of more experience than certainly I have. Bifurcation, I mean, is ANDA BPCIA, is there any place that you can even bifurcate in those proceedings?
They're not generally bifurcated. I mean, certainly I have a case in the District of Delaware, District of New Jersey right now, where we have an antitrust counterclaim. That has been bifurcated, but interestingly, discovery has not been bifurcated. So we are doing all of the discovery despite the patentee's best efforts using every possible rule to try to get out of that. We've continued to push forward with discovery. So
that's somewhat astounding to me, because if you asked about, could I point to one area in an intellectual property law case or a patent case that you'd always get bifurcation, it would be if you've got a Walker process antitrust counterclaim back there. Most trial judges would say, I'm not dealing with this for one very simple reason. You patent lawyers fight like cats and dogs about discovery anyway.
Yep.
I'm not dealing with antitrust discovery before we even know whether there's been a violation, right, for the Walker process. That's just going over in the corner. And antitrust discovery, of course, costs a right arm and a left leg.
Sure does.
I'm very surprised.
The usual would be to bifurcate. I won't get into the facts. The facts are sort of very intertwined with what happened at a PI, et cetera. So it does make more sense. But, it's, I guess, a lesson in don't assume that you'll be bifurcated if it's not what you want. We're bifurcated for trial only, which has been, good for us so far.
Judge Chang, have you had anybody try on for size bifurcation in a patent case that you might have had, or did you? I assume you had some general experience about bifurcation.
Yeah.
And
right. Yeah. No, I don't think I've had like a really full-throated effort to try to bifurcate either the case as a whole or certainly not a jury trial in a patent case. And although there have been attempts in other types of cases, I'm not in favor of, generally speaking, bifurcation of a jury trial. There often is overlap, of witnesses, and there is always extra time that is required in those situations, because then, for the second phase, you're going to have another opening and closing, where some of the facts are going to get repeated because the lawyers are a little concerned that, the jury deliberated for 2 or 3 days and maybe they've forgotten, these particular facts. And then in terms of the jury instructions, I'm going to repeat, some of the general instructions because I'm concerned that, they've forgotten that as well. And so it can really throw the schedule off. Also in a bifurcated jury trial, you also have to decide, am I going to tell the jury ahead of time, that this is bifurcated or not? Because there's that concern that if you tell them, all right, now if you find liability, you will have to stay here, extra days to then talk about damages, and what kind of influence is that going to have on the decision making is of some concern. And my general take on this is, if I have applied Rule 403 correctly in terms of tamping down prejudice from damages arguments or willfulness, that it's still fair to both sides if we just have a single trial, and it is a lot more efficient.
A couple of questions have popped up. When we come back, I'm going to transition to talk about Markman and Daubert's, and then we will get into the real fun stuff about jury trials. A comment. This is more of a comment than a question, at least. Western District of Texas refuses to deny motions to stay pending validity challenges, meaning an IPR, because patentees deserve jury trials, and this particular judicial officer, who's not named, is on record for saying that he can resolve a trial more quickly than the PTAB. And it's not Western District of Texas, it's Judge Albright in Waco in particular. And the question is, do you expect to see more courts following that general view that you're entitled to a jury trial, and because you're entitled to a jury trial, I'm not inclined to grant a stay? That's the question. I guess, Your Honor, this is directed to you more than anybody else.
Well, yeah, I mean, I guess I can't speak for others, but it's up to the Supreme Court to decide the PTAB's constitutionality and Seventh Amendment consistency and all that. So once we have our marching orders, then we have to apply the law as written, I guess. I, like many other judges, have this overall lament, of the decline in jury trials. I think that's something that we greatly enjoy. On the other hand, Rule 56 is mandatory. There was a judge some years ago, not in our district, who I think he issued an opinion saying that, Rule 56 is kind of like a should rule instead of a shall rule. And I obviously I disagree that we can just, kind of override, the mechanisms that are in place to end a case, short of a jury trial, if those are, those requirements are met.
Another question that's popped up, and Elaine, I'm afraid you're going to, well, you or Karen can do, because Karen does a lot of ANDA work. In an ANDA case, can a generic party, knowing the expected dates for certification clause, try to time filing of an IPR so that a decision on institution is expected shortly after the complaint is likely filed? I assume they mean the complaint in the ANDA case. That's getting fairly down in the weeds, but I'm supposed to ask things that pop up in the Q&As. Either of you got a view on that? Elaine, you first maybe, then Karen.
Yeah, I think that can happen in an ANDA case just as it can in a BPCIA litigation. And the question is just, whether it's a good strategy, I guess, is what I would come back to. But I think the timing could work out, sure.
Karen, anything you can add to that?
My experience is similar to Elaine's in that I don't see IPRs playing a major role in ANDA cases. And even when they're filed, there's rarely a motion to stay because most parties want resolution sooner rather than later. So even when IPRs are filed, it's usually not for purposes of seeking a stay, because that would sort of, I would assume, I don't represent generics, I'm usually on the branded side, but I would assume that the reason the generic would want to try to get resolution sooner rather than later, and a stay doesn't really work with that strategy. So.
Right, and actually, Hatch-Waxman allows extension of the 30-month stay under certain circumstances. Right. So if you were a generic and you sought a stay, I think a savvy judge would ask you if you're asking to extend the 30-month stay as well. So there's
I think a lot of people. I think a lot of people who don't do a lot of ANDA work, they know about the 30-month stay, but they don't know that in exceptional situations you can move for it, and some situations it gets granted. Karen, I seem to remember Judge Sleet at one point, I think, granted an extension to a 30 months in a case. That's right. I'm remembering. All right, I want to move on. Judge Chang, there's one more question directed to you, but I'm not going to ask it right now. I'll wait until the very end, because I'm going to end up answering it for you, because you really can't answer this question. Okay, let's talk about Markman and Daubert motions. All right, let's talk about and eliminate motions, the type of things. Markman obviously is very important to everything. I don't know that we need to spend a lot of time about Markman, but I think a couple of things. Your Honor, you're the only one here who's ever had to rule on a Markman construction, and my notes here suggest that you've got some particular guidance based on your experience that you'd like to have everybody know about. So floor is yours.
Yeah, thank you. And this is, just maybe some of this is preaching to the choir, but I think from our judicial perspective, a few tips on briefing and argument on Markman. One is, yes, we're not supposed to construe the claims with regard to, the accused product. It does help, though. I think judges understand the claims and the arguments. If I have a concrete sense of why is this outcome determinative, right? It helps me understand the arguments, much better if I have just a concrete setting. And so I think actually I like, if it's not in the briefs, I will ask at claim construction hearings, like, why does this matter? Like, how is this going to fit in later on? And of course, not because I'm inclined to view one way for one party or the other, but just to help me understand what the arguments are. The second thing is just please do avoid, and I think Elaine mentioned this too, kitchen sink type arguments, just like putting everything in there. The local patent rules have maxima in place on all sorts of things, claim terms, prior art references, and so on. Those are your friends, those limits are your friends, and page limits on briefs, because it does really force you to focus on your best arguments. And it's really quite clear to us, when an argument is being made out of desperation. And I think it reduces the credibility of all your other arguments. So, as angry as you might be, like, as the midnight filing deadline is approaching, and like, how do I get down to 25 prior art references? It's like, we're doing you a favor by forcing you to do that. And then in the claim construction briefing and the joint appendix that is required by our local rules, which has the prosecution history and other materials, I will, if you haven't, I will OCR all those filings, and I will search through those, the prosecution history and the patent itself, of course, for every time the disputed term appears, because I want to understand in context, right? Like, how is that term been used for consistency? So I urge lawyers to do that same thing and put that in the brief as well. Figures, right? Figures in briefs, and of course drawn from the patents themselves. Yes, many years ago when I was getting my engineering degree, I had to learn what each line type meant. I had to, way back when, before CAD was completely prevalent, I had to learn how to spin the mechanical pencil, in a certain way to make a thinner line. And so, but I have forgotten all those things. So when I see a figure and it is a mess of line types and showing the center line, and this is behind it, I don't remember, and most judges never knew, like, what do those things mean? So there are times when it was really helpful to strip out, the clutter that doesn't matter to the claim dispute. So please do help us on that. And then I'll just make one last pet peeve, which is having backup arguments to your claim construction proposals. It's very important. All right, like, so you're the plaintiff. You want to say plain meaning, don't need to construe it. Okay, please do have a backup argument. Like, if you don't think this is plain meaning, then here at the most is what you should say in terms of construing it. And the same thing for defendants, like, this is indefinite. Like, I don't know what it means. No one knows what it means. And it's like, okay, but let's say I disagree with you, and it has to be construed. What would the construction be? And I know, many lawyers think, well, if I offer the backup argument, the judge is going to go right through that. I'm going to lose my primary argument. But we do it all the time outside of patent litigation, statutory interpretation, construing an insurance policy, a contract. Like, we consider the primary arguments, and sometimes you will win that. But if we reject your primary argument, it is infinitely worse to have said nothing about the backup argument. And so, and we're used to it, so please do offer that as well. Okay, I'll get off the soapbox for Markman.
Good Lord.
Sorry.
You were shocked having to take a drafting course in high school at some point. So it's a good thing you didn't go to this high school, because not only did I have to take one course in drawing. This is the Lane Tech. This is the Brooklyn, New York City equivalent of Lane Tech here in Chicago. I had to take 4 years of different drawing courses, including, and I will demonstrate this at some other time, how to draw a perfectly straight line down the side of a piece of paper simply by knowing how to use these 3 fingers of your right hand. All right. Let's talk about, and then I'm getting some questions. Let's talk about Daubert and in limine motions. And I think I want to talk more about in limine motions. Daubert motions, of course, are usually directed to some issue with regard to the qualifications of an expert witness. In limines, of course, are not the same thing as Daubert motions. In limines, in my experience, are odd animals, and differentiating them from summary judgment motions, of course, I think is the bugaboo of many trials. Elaine, are you a big in limine person? Do you file 75 of them or whatever the local rule allows? I know Karen won't file more than 60 in a bad day, and I know her colleague who's not on the line now, not that Jack would ever admit to this, but Jack will file whatever the hell the wind, whichever direction the wind is going in. I'm being facetious. What's your view about in limines?
It's interesting. In patent cases, I feel like the judges are getting more strict about how many you can file. So they'll tell you, you've got 5 and they can't be more than 3 pages each or whatever it is. Which I actually kind of like, because it eliminates that possibility of in limine as summary judgment. And I often think of in limine as not necessarily the evidence will be excluded or limited in some way, but it's an opportunity to give the judge a preview of what you think is important or why certain evidence isn't important, right? And it sort of like sets you up for what might happen later with jury instructions, for example. Now, when I've been involved in antitrust cases, I've been very surprised to see that these sort of plaintiffs' antitrust counsel will file 75 of them, and they're each like 1 page. And that's a really different approach, right? Even in a patent case where it's 5 and they're 3 pages, you're at least citing some law. You see in other contexts, and that's patent related because these are antitrust cases that grow out of patent cases. You see many, many of them, and I find that just ineffective. I think that you're going to get the best attention when you focus on the most important things. Even if you know you're not going to win them, it's still a chance to preview for the court what's going to be important eventually.
Karen, is there any sort of Delaware practice about keeping in limines under control? By the way, and as questions are popping up, and I'm trying to watch the clock and we'll figure the questions out. I seem to remember Judge Sleet used to have a rule that goes back to Markman's that said you get 10 terms. I'll construe anything from 0 to 10, but you're never going to convince me to go over 10. If you don't like it, right, you just preserve that for, I'll note your objection. It'll be preserved in the record, and eventually you'll be able to go down to Washington, D.C. and see if you can convince them that I violated my discretion. So this is in response to a question where the point was some courts force litigants to provide a justification for terms to be included in claim construction to avoid over-lawyering and time wasting. What's the panel think of this approach? So we know Judge Sleet at one point said, yeah, fine, a limit. Judge Tang, do you have a view on that? I can almost guarantee you that if Judge Albright has a view, it's in one of his various orders. I just don't remember which way he goes. I think he has a limit, but I'm not recalling it. Your Honor, what do you think about limiting a number of terms?
Yeah, I mean, the local patent rules, the default is 10. That
right.
They have to be outcome determinative, 10. And then if the parties can't agree, then this is kind of brute force, but 5 for the plaintiff, 5 for the defendant. And then, again, there is a good cause escape hatch. If I've probably done 12 in past cases where the party, and it's usually both sides, will say, well, we really need these 2 extra ones, and here's why. And that's fine. But the patent rules do have a default of 10.
The point that Elaine was making in limines versus summary judgment motions, we talked about this when we did prep, that oftentimes the summary judgment deadline is first you don't get to in limines until after the summary judgments have been ruled on. And I know I've seen in East Texas, oftentimes people try to treat the in limine as a do-over of the summary judgment, or worse, they got, they realized that they forgot to make a summary judgment motion and they try to slide it in on an eliminate. Your Honor's smiling. I assume you've run into that.
Yeah, I mean, for judges, motions in limine and encouraging or discouraging them, it is a tightrope balance that we're walking. On the one hand, I am intensely aware of the jury's time. Okay, and one way to have a smooth operating trial is to have a long and substantive pretrial conferences, and also to encourage motions in limine, where if you really think you can exclude a piece of evidence or a witness, and we don't have to take it up in front of the jury or at a sidebar or have a recess, I invite that. Right? So I actually don't cap the number of motions in limine, although there are some cases where I wish I had in retrospect. But so it's, yeah, the flip side of it is then you get, as you've mentioned, you get like a mini summary judgment motion again, where it's like, look, if I construe the facts in the light most favorable to the non-movement of this motion in limine, no way you're going to win this motion. And the other flavor of improper motions in limine are ones that basically ask me to resolve a factual dispute. They say, oh, look at these great admissions we got, and so you should then exclude this other piece of evidence because these facts are resolved. They're not resolved, like that, unless really no reasonable jury can find those other facts. You can't premise a motion in limine based on fact resolution that is really a jury question.
Karen, is Delaware also pretty tight on in limine?
Yeah,
practice?
Almost all of our judges in their standing orders will limit it to 3 motions in limine per side, 3 pages each, and certainly discourage summary judgment type motions. I think the most effective ones are the relevance versus the prejudice type motions. I mean, one we often see is if there have been IPR proceedings, should there be mention of the IPR proceedings at the jury trial? So really balancing relevance versus prejudice. I think those are the most effective ones that sort of, or do you want to bring in some extraneous evidence about a party that really should be excluded because it's just meant to cause prejudice and not not really relevant to an issue in the case. But I think by design, the fact that in our court, you're typically limited to 3 motions in limine is a reflection that the court has found that they really want to limit their use.
Just looping back for a second on Daubert motions, and then we're going to get into, in our remaining 7.5 minutes, we're going to talk about all the fun stuff that you get to do before you get a verdict. Daubert motions oftentimes attack what's in expert reports, and expert reports, of course, are a constant area of battle back and forth. I have a note here, Your Honor, that you particularly wanted to talk about 26A2B reports, what should be in those reports on pain of exclusion of trial. There was something in particular you wanted to bring out to us.
Yeah, and as our time dwindles, Ken, of course, feel free to just X out all my soapbox material. So on 26,
this is the last soapbox material.
Okay, thank you.
And then I'm going to give you a shout out about the jury charge. You know you're getting one more.
Okay.
Avanti.
So yeah, I mean, A2B is the rules of civil procedure stylistically are actually a pretty decent read, right? But A2B emphasizes, right, and it didn't have to, but it demands a complete statement of all opinions, right, and the basis and reasons. You didn't need the word complete. You don't need the word all, but that was the emphasis of the advisory committee, and so I had to exclude, at pretrial conferences, and there's nothing sadder than a lawyer, realizing that I hid the ball on this opinion or this basis and reason, and now it's coming back, to bite us. And so, please don't think strategically when it comes to the A2B report. It should be the download of everything that the expert has relied on, And yeah, it might make for worse expert disposition, and the cross might be, a little rougher in the deposition, but at least it will not be excluded from trial. Okay, soapbox done.
There's another instance where whose phone number may have to be on your speed dial if you push the envelope too much. Okay, let's talk about, to end our session, let's talk about the joys of juries, jury charges, verdict forms, Rule 50 motions, challenges for cause. We can't talk about all of that, but let's talk first about the jury charge. All right. The jury charge and the verdict form at the end of trials obviously are pretty much the most important thing. Where, Your Honor, and I fess up, this is totally new news to me. I have practiced in the Northern District of Illinois, and before the Seventh Circuit, before the Federal Circuit existed, for at least 5 years. Where does Northern Illinois get its jury charge from in patent cases?
Right. So many years ago, I think over a decade ago, the Seventh Circuit, and one might ask why, but it happened. The Seventh Circuit formed a pattern instruction committee for patent cases, and so I think in 2007 or thereabouts, generated a set of patent instructions. They were just updated last year, and this might be why, Ken, you hadn't encountered them, because they got obsolete pretty fast. As the Supreme Court was taking up case after case on the Federal Circuit, and so we really couldn't use a lot of the elements in defense instruction. Some of the general ones were still fine, but they were just updated last year. I would certainly recommend all the practitioners to refer to them if you need to find jury instructions, because it is a product of a deliberative process of a committee equally balanced between traditional plaintiffs and traditional defense lawyers, and it's made they're generated in the context of, you're supposed to leave your advocacy at the door, right? This is not a particular case that you're litigating. You're just trying to do the public and the practicing bar a service, and the judges a service of deliberative and neutrally expressed instructions. And that's what we try to do for our civil pattern instructions and our criminal pattern instructions, and the same for the patent ones. So it is on the Seventh Circuit website, and it becomes kind of a default. It's not binding, of course, but it is the starting point.
It's very interesting because I have been on the AIPLA committee on and off. I've been on the last several go-rounds, and there's a set of the pattern jury instructions, or exemplary jury instructions, that the AIPLA puts together, and the Federal Circuit Bar Association has a pattern set. They're not binding either, but I never in all that time saw any reference to even the earlier version of this Seventh Circuit pattern set that you've now enlightened me about. I mean, I pulled them up. It's 94 pages long. It has preliminary instructions to be given at the outset of a trial. It's Rule 11.1.1 to 1.18. It has final instructions 11.2 to 11.4. It's annotated with comments from the committee, and it's the patent subcommittee of the Seventh Circuit Pattern Jury Instructions Committee. The most interesting thing is I can't find out who the people are on the patent subcommittee, and I'd assume that the comments that are annotated on the charge come from those people. So that's my homework project. I'm going to try to figure out who that is. My understanding at one point in our prep, Your Honor, is that you'd looked at the AIPLA and the FCBA patterns, and you were concerned that they weren't neutral enough.
Yeah,
they took sides.
Yeah, and it's not a pejorative comment. I think just naturally, if you're from one segment of the bar and represent, a typical set of clients or the other, just naturally you're going to write them in that way, and not out of some, evil villain scheme. But yeah, it was a couple of years ago. I presided over a trial, and they proposed. One side proposed AILPA, and the other side proposed the Federal Circuit Bar Association, and it had to be something in the middle. I had to change things around and edit, and so yeah, I mean, I think, like I said, it's perfectly natural that happens. But that was my experience in that particular case.
Verdict forms, of course, along with a copy of the charge, at least in this day and age, are the things that the jury gets to take into the room for deliberations. The foreperson is usually responsible for filling the verdict form out. I'm a big believer in getting the verdict form resolved as early as possible, because you want to be able to argue from the verdict form. Elaine, Karen, agree, disagree? Which way?
Agree. And I think the court accommodates that. The court understands that's you want to use it in your, at least in the closing, if not sooner.
Would that be consistent with how you view things, Judge Tang, is the right way to do it?
Oh yeah, absolutely. We try to get it done well in advance of trial even, and then at the in-trial jury instructions conference, finalize it before closing.
All right, one last, and I see the hook. Now, hang on, Adam, we're almost there. Closing, time of charge and the order of closing. That's the last two things, Adam. It'll take me a minute. Time of charge, charge before closing argument or after closing argument. Elaine, which way?
In general, I think the judges have a strong preference on that. I mean, if the parties can agree, they might listen to it, but my experience has been judges have a strong preference.
For after?
Yes, for after.
Charging after?
Yeah.
Karen, your view?
Usually after, but the charge will be agreed upon beforehand and can be referenced in the closing.
Well, by rule, it has to be agreed upon beforehand, as I recall it. Your Honor, your view?
I used to be an after, now I'm a before. I think what changed my mind is talking to juries afterwards. I talk to every jury afterwards. Obviously there's a lot of constraints on what I can say, but I'm trying to get constructive feedback from them. And they uniformly told me early on it would have helped to hear it before the plaintiff stood up. And I think it's actually more fair to the plaintiff if they've heard it one time before. And then the plaintiff's lawyer has to do a little less work and consume a little less time on explaining what they're hearing for the very first time. And so I think, and the jurors that process better with listening, it's their second time listening to it. So I think I've gravitated to before now.
And absolutely the last thing, Adam, Rule 50A motions. I'm not going to try to explain that because we've talked about this beforehand. What is the view of each of you individuals? I pretty much know what Elaine and Karen are going to say. What's your view about the obligation to ask people whether they want to make a 50A motion? Because we all know if you don't make a 50A motion, you've got no appeal usually because you can't follow it with a 50B. Do you just let your opponent do whatever? And as a judicial officer, do you just let where the chips fall? Elaine, Karen?
Sorry, I'm turning my microphone on. I live in fear of this. You can't mess it up. So you either need somebody on your team, Ken, as I think you've said, that you've done, who's focused on this solely, or you need your appellate counsel on speed dial to make sure you're getting it right. I err on the side of looking silly that I made a motion that wasn't supposed to be made rather than not making a motion.
Karen?
The only thing I'll add is I think something that should be in terms of the question of do you have an obligation to bring it to somebody's attention? I do think the court is sensitive to that. It's a little awkward for me to help my adversary to tell them to file a motion against me. But I do think it's worth discussing at what level of detail need it be, because that's an area of great uncertainty in the law.
Judge Chang, you get the last word.
I always have a sidebar at the end, the close of plaintiff's case, close of defense case, close of rebuttal case, because I don't want the lawyers to get tripped up on that. And we also at the pretrial conference, I try to emphasize, look, can we all just agree that you'll make the motion, all right, but then you'll put the written reasons for it posted on the docket before midnight of that trial day. And then they start writing it ahead of time, and then they might edit it a little bit, and then they post it to the docket. Everything's preserved, and it doesn't really help the interest of justice to have people get tripped up on the formality like that.
So I apologize in advance to Judge Jordan, but Judge Jordan would not be terribly surprised that I took a little bit of his time. The only chance I've ever gotten to get anything from Judge. I'm kidding. I've tried a couple of cases in front of Judge Jordan. I'm just making a joke here. And Daryl, I thank you. I'm sorry I ran a little long. Adam, thank you for allowing us the extra few minutes. And Elaine, Karen, and Your Honor, fabulous job. I appreciate it.
Yeah.
Beaucoup. Thanks so much.
Thank you all. Thank you, Ken, for moderating.
Yeah, great job, Ken. Nice to see you all.
And thank you. So what we're going to do here is everyone just stick with me. I'm going to clear off the stage. Again, thank you to our panelists. And clear off our stage, and then we are going to introduce Professor Daryl Lim back. You heard from him, if you were here in the morning, you heard from him before. It looks like he'll be joining us. Professor Daryl Lim is, again, the director of the IP Center here at UIC School of Law. He will be introducing our featured speaker. And Daryl?
Thanks, Adam. And thanks, Ken and panelists from the previous 2 sessions. I have enjoyed myself. I trust that the rest of the people who were here earlier too did as well. And here he is, Judge Jordan.
Hey.
How are you?
I'm good, thanks. And I was entertained and educated by the last panel, and not the least bit surprised that Ken went overtime. But I joined the many other people who would much rather listen to Ken than to me. I'm in that group too.
I see that Ken is a recidivist.
Yes. but a lovable one in his own way.
I think adorable might be a good adjective too.
Yeah.
Well, first of all, welcome. We are so pleased to have you. And the title of this keynote, what we call fireside chat, but really it's you're going to be hearing mostly from Judge Jordan, and I'm just here to prop the questions, is the insider's view from the world outside. And this whole seminar is going to be talked about, and we'll be talking about 4 different jurisdictions. One of them, which we don't really think about, is what other circuit courts think about the patent world and these 4 ecosystems: the ITC, the PTAB, the district courts, and the federal circuit that patent attorneys by and large exist in. And Judge Jordan is no stranger to the patent world, and he's very experienced hearing patent cases. We'll be talking a little bit about his background in just a few moments, but he has been a close observer and a key player in many ways in the patent world. So we're very privileged to have you here, Judge Jordan. Now let's start with your professional journey. I'm going to bring us back to 2006 during your confirmation hearing, where you were confirmed by a vote of 91-0, and the entire delegation from Delaware was there to support you. Amongst them, a senator from Delaware, then Senator Biden, and he talked about how you excelled every step of the way. You mentioned your relationship when you clubbed with Judge Latcham, who you called one of the most respected judges to serve on the federal bench. He noted that you had served as assistant AG, partner at a law firm, a general counsel at a corporation, and then you became the district judge in Delaware. So bring us back 15 years as a retrospective, and tell us, what are some of your reflections along the way on this journey?
We make it sound like I couldn't keep a job, Daryl. But yeah, it has been an interesting journey. Hey, speaking of interesting journeys, look, I brought a visual aid here. I want everybody to see this. This is one of my favorite books right here. Daryl Lim's Patent Misuse and Antitrust Law. And I've actually, and I want to know, I have used this book and been educated by this book. So thank you for putting on this program today, Daryl, and for inviting me, and for our past association, and for your work to make sure everybody knows and understands more about the world of intellectual property, including this in-depth look at patent misuse and antitrust law. And although I am my favorite subject to talk about, I will spare people a very lengthy disquisition about Kent Jordan and just say it's been an interesting ride and a surprising one for me. I don't think you can kind of plan out a career to the federal bench and then on the federal bench. You just get lucky. You can do some things that set you up for success, and I did try to do those things, but it was a wonderful thing to be supported by the Delaware congressional delegation, and now looking at it, kind of an interesting and a fun thing to say, well, if a future president of the United States was there and said nice things about me too. But as with most stuff associated with when you're about to put a robe on or you've got a robe on, you learn pretty quickly that people are nice generally, but they're going to be extra nice to you in that setting. And so you just remember to keep your feet on the ground, and you're grateful for the people around you who do that, right? For the spouses and the kids that are remind you that you're a real person and nothing special. I should say something real quick here. One time, this was when I had a teenage son at home, and I was working on a speech I was going to give, and I said, do you want to hear what I'm going to say? And he said, and he stopped, and he said, well, not really, but I'll listen for a minute if I can walk out when it gets boring. That's the kind of grounding you need. And if I start to see all the little figures that show people attending here dropping off one by one, I'll know that they were taking my son's advice. Anyway, enough about me.
Well, thanks for that. And thanks for the very kind shout out. I remember 15 years ago, it was about that time that I interviewed you as part of that book project. And it's been a while, so it's good to see you again, Judge. Now, one quick question before we move on. So you're now on the Third Circuit, right? And the Third Circuit includes the Virgin Islands. So how did that happen?
Well, that goes back a long way, actually. The joke I tell people is it's a tough job, but somebody's got to do it. Go down to the Virgin Islands and hear cases. But the reason the Virgin Islands ended up in the Third Circuit is because there happened to be a powerful congressman from Pennsylvania who was on the necessary committee in the House Judiciary subcommittee that was setting up the boundaries back in the day. It was no more complicated than that, right? Somebody with some swing from the First Circuit got Puerto Rico, and somebody with some swing from the Third Circuit got the Virgin Islands, and it's stayed that way ever since.
Interesting. All right. Well, I know that you want to talk about a number of things related to this conference, and that's part of the big reason why we want to hear from you as well. So let's start with court proceedings post-COVID. Go ahead. What are some of your thoughts on how things are going to look like post-COVID?
Yeah. Well, first, let's talk about that from both the trial and the appellate side. I recognize that I may not have much street cred left as a trial judge, but I still do take trials by designation, and I really only take patent cases by designation, both because I'm interested in the patent law and want to keep my hand in it, and we don't get those patent cases except the occasional reverse payment case coming up to the Third Circuit. Usually patent issues just aren't in front of us. Once in a while there's a licensing case that touches on it. But again, these are all going to our friends like Judge O'Malley, who I think is going to be speaking here down in the Federal Circuit. So to stay involved, I take cases as a district judge, and my colleagues on the District of Delaware who are swimming in patent cases, a lot of patent cases in Delaware, are kind enough to say, yeah, knock yourself out, Ken, and let me take 2 or 3 of those each year. And It's probably to the chagrin of the lawyers on those cases. But it's interesting for me to stay involved. So I think I can speak a little bit to it from the district court side and also from the appellate side. On the district court side, I've had hearings and trial experience remote now. And I would say that I've learned a couple of things from that. One is beware the hot mic, right? People should, this probably goes without saying, but it maybe deserves to be repeated. When you're in a setting like this, you can think I'm muted when you're not. More often you think you're not muted when you are, but it does happen that you think you're muted and you're not, and sometimes say something that maybe was better left unsaid. I actually had that happen in a trial where, you know, the lawyer and his team thought, okay, we're on break and we're not on mic, but they were on mic. And there was a little window into how the trial team was operating, which they probably would rather not have had anybody looking in. But it was impossible not to look in because it was coming right out of my speakers and on my screen and on everybody else's too. So, you know, beware the hot mic. That was true pre-COVID. I think it's just more important now. Pre-COVID, when I was an assistant U.S. attorney, I had a defense lawyer on the other side joking with me, say, hey, where do they fill the water up in this courtroom out of the toilet? This is terrible water. Well, the mic was on, and it was in the judge's chambers. They were listening, and the judge came back on the bench and jerked this chain a little bit. So, you know, this isn't just strictly a COVID time phenomenon, but it's more intense and more important, I think, now, because you're always on mic. Also, I learned that it's important to be paying attention to who's in the room when you've got a witness by remote. In this one trial, a witness was appearing from Europe, and the ordinary things that we've been used to in trials just weren't happening. There was, you know, they wanted to show a document to the witness and come back, and you can't walk up to the witness who's literally 3,000 miles away, hand them the document and say, now turn to page 3. So you go through this routine where the lawyers would say with almost every witness, did you get the box I sent you? Yes. Did you leave it unopened until today? Yes. Would you open the box now? Okay. Now take out the first document. I mean, that's the steps that they're going through. And then this witness began to testify from the document. And from out of the corner of the screen, this hand came in holding a glass of water and handed it to the witness. Well, I think everybody had thought and expected the witness is in this room by himself. And when it was evident that this arm represented an arm that was attached to a person, and that person was not expected to be in the room, some degree of pandemonium broke out in the trial. Like, who's in the room with you? Who are they? How are they related to the case, etc. So I think it's just good to have the ground rules of that regarding that kind of thing laid out carefully in advance, and then there are no surprises and nobody wants to jump up and down. And finally, I would say it's good to be cautious about the casualness that can creep into things when you're in a Zoom setting, because there's something really wonderful about a courtroom and a courthouse. I've spent my whole professional career in courthouses, and so I'm obviously biased, but I think that kind of civic temple feel that you get when you go to a courthouse is a healthy thing to remind people that the exercise we're engaged in is a serious one, and at times a solemn one. It's not one that's without humor from time to time, but it's a serious matter. It should be taken seriously. But when you're in your bedroom or in your den or wherever you are, in a more familiar environment where you feel more casual, there's a tendency to act more casual, to dress more casual, to behave more casually. And I think that's a risk to be avoided when you're making court appearances for argument or for trial. And in trial settings, I've seen the lawyers like actually remove themselves from their homes. Like they go to a room where they're all together, and yet still the behavior can sometimes be a little less than the formality you would want. That doesn't descend into the kitty filter range, right? The infamous Texas kitty filter lawyer, but it can get more casual than is helpful for the process, and that's true for witnesses too. I think you should encourage your witnesses to be dressed professionally, behave professionally. You might have to run through things with them to get them into that zone, but you want them in that zone because it can affect credibility.
Thanks, Judge. A couple of things. One is, folks in the audience, if you have questions for the judge, please feel free to use the Q&A feature. We'll be taking questions throughout. Follow-up questions from just based on what you said. One is this: during the PTAB session, there was a sense that quite going back to the way we were pre-COVID in terms of hearings. They're going to be remote hearings, be a part of practice going forward. Now, you did mention some of these concerns about being casual. Is that just a change in culture? You think that the legal community, and particularly the patent community, will have to accept whether you are on the side of the bench or whether you're on the side of the bar and adapt to that? Or should we, even in this virtual environment, which may be a long-term one going forward, or at least a hybrid one, be able to establish certain norms and stick to them? And who should be doing that?
Well, the court, of course, will have a role in that, but the lawyers have an important role in it too. I just think it is incumbent on us as more things take place remotely. I personally am eager to get back in the courtroom. I think it's very helpful to be in the courtroom for oral argument, and certainly a lot easier to be in the courtroom for taking evidence in the court of first instance. But even for oral argument, which is not that tough to do remotely, I mean, I heard an argument in a case this morning. When we're finished here, I'm going to hear argument in 2 more cases this afternoon. I don't have to leave this chair. It's in that sense, it's convenient. But I'm eager to get back in the courtroom because I think there's very little substitute for in-person interaction. It's easier to sense things in the courtroom. It's easier to sense what the advocates are trying to do because there's no delay. It's much easier to sense what your colleagues on the panel are trying to do. You know, you can still pick it up. Now, if you're on a phone call, a teleconference, you can't read body language at all. You can read some body language on a video, but it's just not comparable, in my view. I should say comparable. It's not as good as being with each other, where the nuances of behavior are more obvious and you can pick up on those cues. And if I were an advocate, I'd want to be in the courtroom for exactly those reasons. Having said that, I think there are going to be more arguments in the district courts and some in the courts of appeals where people are going to be more willing to or wanting to handle them remotely, and we're just going to work that out going forward. The depositions, I expect a lot of those are going to stay remote. The cost savings have got to be enormous in time, travel, lodging, attorney billing. I just think a lot of that is, that's not going away, I don't think.
Thanks. Second follow-up question. We were talking about the bar in Delaware, and of course, Delaware has always been a major patent litigation venue, even before the Eastern District of Texas and now the Western District of Texas. How does the bar in Delaware view what's going on in Texas? Does it feel like business is going out? Are they saying, thank God, they're sick and tired of these cases and glad it's spreading around? And to what extent do you see this actually spreading to other parts of the country?
Yeah, you try to get me in trouble. I have nothing but happy things to say about our friends in Texas. I will say that at one point, not long after T.C. Heartland, I spoke to a friend on one of the Texas trial benches and said, has it changed things much for you? And this judge said, well, we sent some of the weaker cases to you in Delaware. And that was said with a smile, which was only half facetious, I think. I think Texas has got plenty to recommend at this venue that they don't have to worry about having lost a bunch of cases. They still have a strong docket there. And Delaware cases continue to be, from what I can tell, interesting and engaging, and there's enough to go around. So now I'm not close enough to the practicing bar right now to know what the bar thinks about it. I think from the bench side, we're just doing our job. The district court judges are doing a great job here in Delaware, and from what I can tell, they're doing a fine job in Texas too.
Great. All right. Exercising good sense in Section 101 motions. We touched actually a little bit about that this morning as well. What is your take on this issue?
Well, just that. I wish I'd tuned in and heard what people said this morning. My impression is that some of the immediate post-Alice craziness is gone, but there are still cases that surprise me, and I'm not soaking in it the way my colleagues are here, and the way district court judges are. Like I said, at any given time I might have 2 to 4 patent cases, so I'm not seeing it in the depth that the heavy patent docket district court judges are. So I should be careful about, generalizing, but I am surprised that somebody will try to say, well, in an ANDA case where you're talking about a molecule, well, this is really not covered. But this is non-patentable subject matter. You're like, what are you talking about? Why would you say that? Why would you take my time and your time and the other side's time? And they've constructed an argument, but it's pretty much of a stretch. And so it still happens where you should scratch your head and go, I'm not sure why we're dealing with that. And you hope people will exercise better judgment. But Alice is what it is, and creative lawyers, being who they are going to be finding ways to keep bringing these motions. I just hope they'll exercise good judgment about it.
So talking about motions, one big issue is also stay motions in the district courts. What are your views on how they are being exercised right now? And talk about a little bit about the dynamics, perhaps between the district court and the other competing jurisdictions we are hearing about today, the PTAB and the ITC.
Yeah. Well, I used to be indecisive on this, but now I'm not so sure, Daryl. Actually, back in the day, it was a pre-AIA. It was easier because you just typically, I was a district judge in those days and would seldom grant a stay because you didn't know whether an ex parte re-exam was ever going to result in something or how long it was going to take, et cetera. So you just say, no, we're going to do our thing and they'll do their thing. Well, we're in a very, very different world, and watching how the PTAB, when it chooses to institute and not, judges are keeping their eyes on that so that nobody's wasting anybody else's time. The context has changed. If you're working with a judge that hasn't seen a lot of these cases, you need to be understanding about that, I would think, as a practitioner, because the landscape did shift. And I think in the mine run of cases, most judges are not ready to stay a case because something's happened in an administrative agency. They'll pay attention, but they won't understand that there's a dynamic that's been worked out here. And you might have to help them understand the context. It reminds me of a story. A guy said, I had the craziest day. I found this hat full of money, and so I thought, this is great. I picked it up, and all of a sudden I was being chased by an angry guy with a guitar. Well, if you didn't understand that there are buskers out there who put a hat down and play, you might not, appreciate, I shouldn't walk away with the hat full of money. If you don't understand that the PTAB is out there and it's doing its thing, and that you, as a district court judge, have need to keep your eye on that in a way that you might not have to with some other administrative agencies. You might be forgiven for not appreciating the context, and the patent lawyers who are doing the litigating around the country are going to have to help district court judges understand that, I think.
Okay, thanks. I see a question there, but I'm going to ask you one question first before I get to that. In 2006, you were, of course, you had your confirmation hearings, but then you also were part of the State and Federal Circuit. And John Whalen, who was moderating the panel at the time, asked you this question, whether it was a good idea that the Supreme Court was taking Federal Circuit cases. And you talked about how there was this dialogue, at least that happened between the Supreme Court and the Federal Circuit. Well, the first question is, has your view on that changed since? Question is just looking horizontally. Is there a dialogue now that's going on between the ITC, the PTAB, and the district courts? And is that a good dialogue?
There was a period of time where the Supreme Court was taking a lot of cases from the Federal Circuit comparatively to what it used to do. I think that's slowed down some. That's at least my perception. It's slowed down some, but I'll let people who are scholars and paying attention to this more carefully than I am have the real word on this. But I do believe there continues to be a natural tension that exists when you have two appellate courts of national jurisdiction looking at the same subject matter. There's no other area of law where you've got that going on. And the Federal Circuit, when it was formed in the early 80s, I think rightly understood that part of their responsibility was to rationalize patent law across the country. For every other area of the law, we trust the Supreme Court to do that, right? It's a bit of an oddity, and I think we should just acknowledge and embrace it, that somehow, and you could lay this at the Supreme Court's door. Maybe if the Supreme Court took cases on cert the way it should have back in the 60s and 70s, there wouldn't have been the agitating that there was in the business community for a court that would straighten out differences and significant differences amongst the regional circuits on patent law. But the court wasn't taking those cases much, and so we got the Federal Circuit to help handle that problem. And now it creates its own issue, which is the Federal Circuit does its utmost to rationalize the law across the country, and then the Supreme Court wants to come in and say, "No, we don't like the way you did that." And I do think that creates something of a natural tension, and you can see it emerge in the language sometimes that comes out of the court. I think one of the most telling things written on this was from Justice Breyer in his dissent to the dismissal of cert as improvidently granted in the LabCorp case back, 15 years ago or so. It's been a while. But at the close of that, he really wanted to take that case. And he got to do it later. Like, I think, Mayo was just LabCorp Redux. And he really wanted to say something. And at the end of that dissent, he says something to the effect of, I think this generalist court has something to say to these issues. There's a feeling from time to time, I think, from the Supreme Court that the Federal Circuit has got a particular view, and that more generalist court maybe wants to speak to it. And that's so I don't think the dialogue is going to go away between those two courts. It's just a different dynamic than there is between generally speaking, between the regional circuits, because the Federal Circuit's got a national jurisdiction just the way the Supreme Court does.
Thanks. And to the second question, as to the dialogue between the ITC, the PTAB, and the district court, do you see it as healthy, unhealthy? Are you happy with the way it's going?
I think emphatically nobody cares whether I'm happy or not about that, Daryl. I think I'm somewhat nonplussed about the development of the PTAB, because it is such an interesting and unique creature where you've got an administrative tribunal that is now driving so much of the law in this area of the law. You know, I'm not anti-PTAB, but I thought that Justice Gorsuch and Chief Justice Roberts had a credible position in oil states, that there's still there's a sensible argument to be made that the kinds of things the PTAB's deciding should maybe be decided in a Article 3 court, which ostensibly stands apart from the executive when an agency does not. But that's a philosophical point. As a practical matter, I've got former law clerks who are PTAB judges. I know a lot of other PTAB judges. I know how hard they work. I know how dedicated they are. I know how serious they are about their work. I know that the practice is developed in a way that takes account of it, and that we're just adjusting to that system. And it is what it is. And when you've got all the actors acting in good faith in the district courts, in the PTAB, in the ITC, you know, we're gonna hit a stasis, we're gonna hit an equilibrium, and people will just need to be happy with it because it's here to stay.
Oh, just very quickly, because I think it's an important point, and contrary to what you might say out of humility, Judge Jordan, I think many people would be interested to hear what you have to say, not just about patents, but IP in general, because you are an important voice in this conversation. So what just looking ahead the next 10 years, what are some of the things that folks on this call should be thinking about in terms of patents and in particular these institutions?
You know, one of the things that has been troubling me, and it continues to trouble me, and I think will, and I'm afraid will continue to trouble me, is why we can't seem to get a set of understandings about injunctive relief in place that allow patent holders to fully enjoy the exclusive rights they're supposed to enjoy. You know, I don't understand why eBay has, I'm not quite sure I understand why eBay's interpreted the way it has. My good friend Paul Michel says, and I agree with him, why does the Justice Kennedy concurrence seem to carry more weight than the Chief Justice Roberts concurrence? They both are concurrences, and there was nothing in the majority opinion that made it necessarily the case we would end up where we are, but we are where we are, and where we seem to be is where injunctions are not following in instances where you just would think they would. It's too easy to say, I think, as a intellectual matter, you know, not looking at any particular case. Every case got to be judged on its merits. Hasten to add. But I'm very taken by the Chief Justice's observation that we're not writing on a clean slate here. There's a long history, and there's and the exclusive right ought to mean something. And if all you're going to say is, look, you can make up money after we can give you money later if we actually did this wrong, then what happened to the exclusive right? Right? Now, I do understand the context in which that arose, and there are instances where you can say the disruption to the economy would be so significant, or the upending of an industry would be so significant that we just can't allow that to go forward. But I do candidly have, that's if you said, here's what are the things that trouble you, that would be on my list. And a second thing, and I wouldn't say this troubles me, but I'm going to be interested to see how it works out, is to see the increasing traction that the Defend Trade Secret Act has got. I heard a DTSA case this morning. I heard one 3-4 months ago. I didn't know when I would ever see one, but they seem to be coming a little bit more frequently, and I think it's going to be interesting in federal practice to see how that works and to see how the DTSA might intersect more and be brought into patent cases where you have a set of proprietary information that's also involved with stuff that might be patented, where things might both be happening at the same time. I'm going to be looking forward to seeing both those things, how the DTSA gets litigated in federal courts more frequently, as I think it will, and if and when and how it might end up showing up in some patent cases.
All right, thanks, Judge. In the last minute or so, I just want to invite you to respond to the question that we have from the audience, if you have one, and close us off with some remarks. And we are abutting against a fairly long break. That's why I'm a little bit more liberal with this round of our next sessions at 12, and we're taking a break before that. But Judge, any thoughts on the question from the audience? Judge Chang mentioned that 7th Circuit drafted compiled patent instructions. I think they meant patent as in P-A-T-E, well, patent P-A-T-E-N-T. Do you see the 3rd Circuit drafting their own, and why?
Yeah, I would be surprised if the 3rd Circuit created model patent jury instructions. And the reason I'd be surprised about that is because the jurisdictions in the 3rd Circuit, New Jersey, Pennsylvania, Delaware, and as you noted, the Virgin Islands, the courts across this circuit are pretty tuned in. You know, in the Virgin Islands, I don't think, if there's ever been a patent case there, I'm not aware of it. That's not something they really need to deal with very much, if at all. New Jersey has a goodly number of patent cases, lots of ANDA cases. The Western District of Pennsylvania and the Eastern District have both got some patent cases and have paid attention to, with local rules and things like that, how they're going to manage patent cases. Off the top of my head, I don't know that the Middle District does, Pennsylvania. Delaware certainly has lots of experience with these cases, and I think the 3rd Circuit, I don't want to speak for my colleagues here, but just from my perspective, I think my feeling is these courts are doing an admirable job of dealing with their patent-specific issues, either with standing orders in the courts or with model jury instructions or things like that, and they don't need a set of patent instructions necessarily that's blessed by the 3rd Circuit to manage that. Now, that could change over time. There could be a feeling that develops in the different districts that, no, this would be a helpful thing for us. And if there were that feeling, you know, I think people would be open to looking at it. But there's a due and a proper degree of humility which goes with being an appellate judge. And our colleagues on the district court are kind enough not to say it very often, but stay in your lane is one of the messages that ought to be playing in our heads as appellate judges. Stay in our own lane, and as long as the district courts are managing this kind of thing effectively, and my impression is in the 3rd Circuit they're handling it quite well, there's not a need or a desire for us to get engaged there.
Well, thanks very much. And again, thank you for joining us today. I hope you'll join us for some or all of the rest of the afternoon. Do you have anything to say to the audience before we sign off?
No, just I wish I was there in person with y'all. It would be nice to get to see people, and I thank Adam for managing the tech side of this, making us look and sound better than we probably deserve. Thank you. And thank you, Daryl, again for the invite. Thank Ken and the other organizers for the chance to be with you. I appreciate it.
Thank you, Judge.
Bye-bye.
Well, thank you. Thank you, Daryl and Judge Jordan. I would like to note, though, that I can't do much for the appearance, so all the good looks comes from your end. So What we're going to do now is we're going to transition from presenter mode back to the table mode. There will be a short break. It's going to actually be shorter than we had originally planned on the program, just because we were running a little over. But what we will be doing is when we go back to the table setting, you'll at the bottom right hand of the screen, you will see a blue button that says click here for room 2. Click on that button, follow the green link, and it should take you directly to our next room. We will have student ambassadors making their rounds throughout the floors, throughout the tables, to make sure everybody gets transitioned well. And we would like to pick back up for session 3 at noon Central. So yeah, I will see you all there. Hello, welcome back, everybody. I hope you're able to take some time and speak with some people. We are now getting into our third session, which is the International Trade Commission panel. I will be inviting those panelists up to the stage now. This panel is moderated by Blaney Harper. Blaney is a partner at Jones Day. And again, just a reminder, I know I mentioned this in the morning sessions, but moderators and introductions, try to keep them relatively short. Names, titles, affiliations. Like I said, like I previously mentioned, if attendees want any more details, they can access the seminar materials, which again are located in the top left-hand side of the floor plan. And I will be also posting a link in the chat here as soon as I disappear. Yeah, just as a reminder, keep an eye on the Q&A tab, and take it away, Blaney.
Well, thanks a lot, Adam. And I really appreciate the opportunity to be with this panel today and actually to see the whole presentation. It has been very enlightening up to this point, and I hope to help in the brightness of the whole topic. What we're going to do in this session is talk about another of the ecospheres in the patent world, which is the ITC, and we are going to have a series of speakers that are just excellent. They have a lot of experience. They are really tied into the practicalities of litigating in the ITC. We're going to spend a little bit of time giving an overview, because I think sometimes the differences between litigating in the ITC and litigating in district court are just a little bit overlooked, and they can be important, and they can have ramifications that are unexpected and a little bit surprising. So it's worth spending a little time refreshing ourselves and going over some of these topics. The speakers that we have today, who's going to go first is Tom Schomburg. He's a named partner at Aducci, Mastriani, and Schomburg, and he's been there since forever. So that's a pretty good recommendation in and of itself. And frankly, he wrote the book. I mean, literally, the man wrote the book. So it's a real honor to have him here. Artie Shaw is a partner at Kilpatrick, Townsend, and Stockton. She's been on so many ITC cases, it's hard to count. So it's, her practicality and insight is very much in demand. We also have Lei Mei, who, founds his own firm. It's really a pleasure to be with him and talk to him. He's a founding partner of May and Mark. And then we have Ted Essex, who's a former ALJ at the ITC, and we need a judge to keep us straight. And Ted does a lot of that. So I really hope that the following little time that we get to spend is enlightening and maybe even entertaining if we're lucky. So with that, our first speaker will be Tom, and he's going to give us a bit of an overview on the ITC and the practice. Go ahead, Tom.
Thanks, Blaney, and hello to everyone. Yes, it's a great panel, and I'm glad to be part of it, and want to thank the law school for inviting me. I'm going to be talking with a few slides. You don't need to put them up yet, Blaney, but thanks for your eagerness. Let me just start with a background about the ITC, which I'm sure everybody understands is one of the administrative agencies we have in Washington, D.C. It actually goes back to the New Deal, 1930, but for purposes of the modern Section 337 statute, it really begins in 1974. And the reason for that is primarily that when Congress amended the law in that year, it added a very important feature to Section 337, i.e. that cases would become subject to the Administrative Procedure Act, and that, of course, guarantees due process. It guarantees a judge or a group of judges. And from that point forward, Section 337 really became a much more important statute, and I would say largely in the intellectual property field, but not limited to that. So we're up to about case 1200 and something. So that is the number of cases. Each one gets a new number, starting with number 1. So that's roughly the number of cases there have been since 1974. Talking a little bit about the commission itself, to the extent people are not familiar with it. Even for Washington, it's an unusual administrative agency. In that it was created to be sort of politically neutral. Unlike other agencies, there's an equal number of commissioners. In the case of the ITC, it's 6. No more than 3 can be from the same political party. And perhaps equally importantly, the chairmanship rotates, and it rotates not only every 2 years, it also rotates between or even among political parties. You could have an independent as chairman, a Republican, a Democrat. So there is no, I would say, and Ted might have some thoughts on this, there is no real power center at the ITC. It's a group of commissioners who are trying to do their job under a statute that is subject to the APA, and that, of course, gets us to the next level, which are really the important people in these cases, and those are the administrative law judges. There was a time where there was 1, then it went to 2, and ultimately the largest number the commission has had is 6 judges, of whom Ted Essex was one, and one very good one, and one who did not mince words about how he viewed cases. But if you were on the winning side, you loved what he said. And if you were on the losing side, you pretty well understood why you lost. Right now, there happen to be 5 judges, or at least one is about to depart. So there is an opening. Historically, the judges did not necessarily have technical, i.e. patent or engineering backgrounds. They were principally brought on because they understood litigation, and they were often brought on from the Social Security Administration or other agencies that had due process hearings. And I think it's fair to say that not having started with an IP background, all of the judges who have come through the commission have done a heck of a job of understanding particularly patent law, which of course would be novel, as well as some of the other issues that come up before them in the various cases that they hear. It's also important to understand that these are actually three-party proceedings, at least more often than not. There is a complainant, the typical plaintiff. There is at least one respondent, perhaps more. And then the third party can well be, and I think Artie had that experience for a number of years, can be an attorney from the Office of Unfair Import Investigations. Once again, that's an independent office within the commission whose responsibility it is when they choose now to be part of an investigation, essentially to be a neutral party, to do the best they can to bring all the facts forward that perhaps the other parties have not brought to bear. And we'll talk about this a little bit more going forward, to make sure that the public interest is protected, because the commission's authority is quite significant, and the staff of the Office of Unfair Import Investigations is often charged with making sure that the judge and in turn the commission fully understands the public interest issues that come before them in these cases. But moving on from what we call OUII, you also have a general counsel's office. Those are people who I believe 100% that are involved with Section 337 do have technical degrees and backgrounds. On top of that, each commissioner typically has at least one person on staff who is a Section 337 practitioner, keeping in mind that another major part of the commission's jurisdiction is in the areas of anti-dumping and countervailing duties. We're not talking about those today, but that is also a critical function of each commissioner's job. And the commissioners typically have people who are adept at those areas as well. But the key here is you have OUII, where you have a neutral attorney. You have the general counsel's office that oversees what is going on in these cases. You have the commissioner's staff. You have an administrative law judge who does nothing other than decide 337 cases. Historically, I think we could have said they were 95% patent cases. They have moved a little bit, as Judge Jordan mentioned a moment ago, somewhat into the trade secret area, antitrust, passing off, common law types of issues. But for the most part, they still remain, and I'd say 90% is probably a fair measure. They remain as patent cases, or at least have a patent as part of the case, perhaps joined with a trade secret, perhaps with a common law account of, who knows, passing off or what have you. So the point of all this is to say that by the time you get through the commission in a 337 case, you've had a lot of eyes on the issues in the case. And finally, the commission makes its decision, and then you would have the same appeal that you have in a federal court from any other patent decision. You go to the CAFC. And we're not going to talk very much about that because everybody is presumed at least to be familiar with that. But that is the reviewing court for all of the commission's decisions. So again, the point is, by the time you get to the end of the process, you've had a pretty good shake on all the legal arguments, all the facts that might have a bearing on the outcome of the case. And if you would, Blaney, put up the first slide where I'd like to just point out a few of the differences between what goes on at the commission and what happens in your typical district court case. And of course, it does differ from court to court. But As I will be talking about later, there's an 18-month typical deadline for these cases at the ITC. District court cases, obviously, in Texas go faster. Other places go slower. 3 years seems to be a relevant median. And I won't go through all of these, but at the ITC, you can join all of the parties that you might want to join because jurisdiction is in rem. And so you're actually joining the products of those parties, the parties themselves, or the producers, importers, what have you, to participate or not. Again, you have broad discovery. It's nationwide subpoena power that the judges have. However, they cannot enforce their own subpoenas. That has to be done in district court. We've already, and I should say that that does not happen with any great frequency because people usually work out subpoena issues. There tends to be a lot of cooperation between the ITC practitioner and perhaps the counsel who comes in on behalf of a third party. They tend to narrow the discovery to a point where the third party says, okay, I'm willing to do this much, but not more, and that usually avoids the district court practice. We've already talked about the judges. As to confidentiality, the commission takes its responsibility there extremely seriously. What that means is you don't have the negotiations that you often have in district court. The protective order is issued immediately, and it's typically limited only to counsel and outside experts, all of whom have to sign confidentiality agreements. We're going to be talking, I think, a little bit about remedies during this session. It is worth mentioning, as Judge Jordan just did, he questions whether eBay has perhaps made it too difficult to get an injunction in district court. The commission, on the other hand, essentially issues injunctions. It does not award monetary damages. So it's either an injunction or a cease and desist order, which is injunctive in nature. So that is one reason complainants come to the commission, because they can get the type of injunctive relief that's very difficult to get in district court. I won't go into detail on this, but there is a preliminary injunction available at the commission, which has pretty much gone out of use because it's so difficult to prove irreparable harm in a proceeding that by definition is very short term. So you have a tough time proving that you're going to be irreparably harmed if you can look forward to an injunction in the relatively near future. And one of the unusual features of the commission's jurisdiction is it can issue what are called limited exclusion order, which I like to call a specific exclusion order against all the products and parties that came before it. But it can go a step further under the right circumstances and issue what's known as a general exclusion order, which would exclude products that are subject to the same patent infringement arguments as were the ones that were before the commission in the particular case, but that party that may be also infringing the patents in question might not have been before the commission, yet a general exclusion order will issue. Let me go on. Glenn, you can take that down. As we'll see, there are also some disadvantages. Just if you would, Blaney, the second slide, just pop it up for a moment. It gives you a sense of the history of the caseload. That's slide one. There you go. This is just a 15-year period. As you can see, the number of cases in the second column went up significantly into 2016. Those were the cell phone wars, so to speak. It's dropped back into the area of roughly 50 new investigations per year. But it's the fourth column that's kind of interesting. Back in 2006, there were maybe 70 active investigations, which includes the carryover from the previous year, any ancillary proceedings that might have been extant. So you're looking at 70 active investigations. If you go down to 2020, you see that number is now up to 120. So the commission has been, quite busy. Let me talk a little. You can take that down, Blaney. Let me talk a little bit about what it takes to bring a case. I can do it without the slide or with the slide, Blaney. But essentially, you have three issues that you must be prepared to pursue at the commission. The most important one is you have to have an importation. Section 337 is a trade statute, and so you have to have a good that is being imported directly or indirectly. Then you need an unfair act, and let's say for purposes of discussion, it's patent infringement. And then finally, you have to have what's known as a domestic industry. Again, because Section 337 is a trade statute, it isn't protecting intellectual property in a general sense. It's only protecting intellectual property which in some fashion is being used within the United States. I'm going to stop there because we can talk about domestic industry extensively, as Lei will do in a few minutes. So let me move on to the fourth factor, and that's only for non-statutory IP, where you might also have where you would have an injury test, and those would be a trade secret case, antitrust case, passing off common law trademark, and so you have to be prepared to prove injury in those cases. And in the good old days, you had to do that in every case, but the statute was amended to remove the injury test in so-called statutory IP cases, patents, trademarks, and copyrights. Let me move on to the timeline, which is actually the third slide, Blaney, or it's actually the fourth, excuse me. You get that? Well, one of the, Blaney, can you put the fourth slide on? This is
I think it's up there.
A very good way to understand the.
Not up there?
Sorry? No, it's not up.
Oh, well.
Help.
Yeah.
No problem. Basically, what this time, there it is. Thank you. It's a flashing timeline.
Yeah, I don't know how that happens.
I'm sure Adam will fix it. There you go. Nope. Just quickly, the timeline explains that a typical ITC case, whether it's patent, trademark, trade secret, antitrust, really proceeds over a period, thank you, of 18 months, beginning from the time that the complaint is filed. It is reviewed by that Office of Unfair Import Investigations I mentioned earlier, that checks it just for adequacy to make sure you've touched all the bases of the Commission's rules. They don't make a substantive judgment about the case. It's also at that point that the complaining party has to put in its position on why it is, I guess, in favor of the public interest for this case to be decided by the Commission in its favor. And then any named respondent, even though it has not yet filed a notice of appearance, is given the opportunity to contest the public interest aspect of the case. But as you can, well, as I had hoped you could see on the timeline, all of the discovery in these cases usually takes place in roughly 4, 5, 6 months, because the hearings, meaning the trial, due process, the whole 9 yards, takes place somewhere between the 7th and 9th month. depending on the judge and the judge's own schedule, all of which is established at the beginning of the case. Before that, you can have a Markman hearing, you have motions practice, you have all of the discovery tools that you have in federal court, interrogatories, document requests. You can even get access to foreign facilities. If it's a process patent case, they can, of course, refuse to give you access, in which case the judge will kindly issue sanctions, because it's presumed that had you had access, you would have found what you were looking for. So you have all the discovery tools. You have very specific rules at the commission on how all of this moves forward. You have the judge's own ground rules, again, that provide a very good roadmap on what is expected of the parties, all of which gets you to the judge's decision roughly at the end of 12 months, which is what the statute used to provide as a matter of law, but has now become simply a matter of practice, using the term at the earliest practicable time. So after 12 months, you find out what the judge's rulings are on the merits of the case, and then each side has the opportunity, and by the way, that includes the Office of Unfair Import Investigations, to appeal the entire case or parts thereof to the commission. The commission then has discretionary review. It can hear as many of the issues as the parties choose to put before it. It can choose to take none of them, or it can add its own issues. If the last slides can be put up, I just want to say a word about the outcome of these cases, and I'm sorry if it seems like I'm rushing a little bit, but we don't have a lot of time. To give you a sense, there it is. As you can see, and that's the last slide, I believe. Can you put up the one before that? Yes, what that shows in the blue area, you see violations are found in roughly 41% of the cases. You have settlements up there in the yellow area of 18.5%, which settlements or consent orders typically favor the complaining party. So that gives you, a rough percentage of, call it 60%. Outcome at that point in favor of the complainant. Where it says withdrawn complaint, 14.8%, some of those are withdrawn because there are problems that the complainant encounters, but some are also withdrawn because the parties enter into a private settlement that never gets before the commission. The next slide is the one that I think is very interesting. And it's the one on the right that tells you what happens, at least in the year 2020, in cases that actually go to trial. So no settlements, no withdrawals, no consent orders, but now these are the cases that actually go before the judges. And I know that when I gave this talk, let's say even a few years ago, they were roughly 50-50 in favor of neither party, i.e. complainant or respondent. It seems now to have tilted a little bit more to the violation side. But all of this is to say that if your case survives all the way to the hearing stage, you get a pretty fair shake, whether you're on the complainant's side or the respondent's side, meaning you have roughly a 50-50 chance of winning the case if you can get that far. And I think that reflects the care with which the judges, as well as the commission, bring to the decision-making process. Let me end with that, Blaney, and say thank you.
So, Tom, before we move on, I just wanted to ask one question for the edification of the audience. Is what is the relationship between the decision that comes out of the commission and its effect in a district court action?
Well, that the short answer is that there is a part of the statute now that came out of a case roughly 30, 40 years ago, which says that if a complainant files both a district court case and an ITC case, the respondent defendant is absolutely entitled to a stay in district court so that it does not have to defend itself in two fora at the same time. And I think history has shown that in virtually every situation where the same patents are being asserted, both in the district court and the ITC, the respondent avails himself of that option. And so the district court has stayed, the ITC case goes forward. The ITC decision is not res judicata, but at least not in the patent field, but the district court judges are entitled to take what the ITC has done into consideration.
Well, thank you very much. I know it's a lot of material to cover as an overview. It's very comprehensive, and it's takes a lot of detail. I know you've skimmed over some things, and we'll talk about a few of those. The first of those will be the fact that the ITC does not just deal with patents. The ITC actually deals with other things, believe it or not, other kinds of intellectual property. And to spend a little time on that, we have Artie Shaw, who's going to detail some of those issues. Artie?
Thanks, Blaney. And hello, everyone. Like Tom said, I'm delighted to be part of a panel with such wonderful practitioners, and so happy to be speaking to you, and I'm glad and appreciate Professor Lim inviting us here today. Blaney, do you mind putting up the first slide, please? I mean, if you can't, it's okay. Okay. So this slide just has a portion of the relevant statute. Like Blaney said, so many people seem to forget that the ITC does more than just patent cases. And this is the part of the statute that gives them authority to do this. This is, Section A of 337 declares that unfair methods of competition and unfair acts, sorry, 1 minute, are violations. And Tom has gone over some of this, but it's, you may have noticed that the phrase, what is an unfair method of competition? What's an unfair act? It seems fairly vague, and that's true in the sense that the statute has been construed to encompass a lot of things. As Tom mentioned, it can be unregistered trademarks. It can be like false advertising, false designation of origin, Lanham Act violations. There's gray market cases. There's even sort of non-patent causes of action or non-intellectual property causes of action, in the sense that people have brought antitrust actions under this. And even they brought investigation for non-compliance with FDA regulations. So the jurisdiction is pretty broad, and in recent years, there's been an interest in sort of, or at least a pattern of testing this, investigating what is and isn't allowable. So it'll be interesting to see how that evolves. But as Tom also mentioned, perhaps the most common thing that this is used to provide support for is an allegation of trade secret misappropriation. but getting back to the broadness of this, Tom and I actually had a trade secret case a while ago. I'll be discussing it, but it went to the Federal Circuit, and during the oral arguments, Judge Moore seemed particularly bothered by the vagueness of this language. And she threw out this hypothetical that, for example, could this section be used to bar products made in China that were made with prison labor because, it's a violation of certain laws? And, there's no clear action or no clear answer on that. So, like I said, pretty broad. So you can turn that, or you can take the slide down, Blaney, if you want. The test for trade secret infringement is generally at the ITC is generally the same as it is at the district courts, right? You have to prove that something was a trade secret by showing you took measures to keep it secret and it was not generally known. And you have to show that you derived economic value from it not being generally known. And then for the misappropriation part, you have to show that it was acquired or disclosed by someone who basically had reason to know it was secret. Like in district court, in the ITC, the common defenses are that the defendant acquired it or invented it independently, that it wasn't a trade secret, for example. It was generally known in the industry that you have to do X, or that the purported owner of the IP had disclosed it to so many people it was essentially not a secret, or that they just generally didn't take proper measures to treat it as a secret. So couldn't then allege violations of trade secrets. That's the elements of this. And then if you win at the ITC, there's a question of how long the exclusion order will issue. With patents or trademarks, it's easy to determine how long the exclusion order will run. Exclusion orders, for patents go until the patents expire or they're invalidated. But with trade secrets, there's no such set limitations. So in those cases, the judges and the commission sort of look at the facts and decide. I mean, there are decisions, I think, anywhere from 20 months to 10 years, and it's pretty fact dependent. The other thing to note about trade secret cases is, as Tom mentioned, there's the injury requirement. In most ITC cases, you just have to show domestic industry, and those are the ones with like patents and registered trademarks. Here, you do have to prove injury, which is a bit unusual. You generally have to show that there's a domestic industry in a product that competes with the allegedly infringing products and that it's being harmed. There are a number of ways you can show this. You can show it by showing lost profits or lost market share, or that the other side undersold you, so then you have to reduce prices. There's a number of ways of doing it, but you do have to show that there's an industry being harmed. And you don't have to do this with patent or trademark cases. Could you go to the next slide, please? Oh, this is interesting. There's a great question. Someone has asked, Jeffrey Ward has asked, is the length of the injunction typically based on the amount of time it took the trade secret holder to develop the trade secret? I would say that is okay. Judge Essex would like, maybe I'll defer to Judge Essex on this.
Well, yeah, I just have been working on one of these for some time. It's essentially what they are supposed to try to do is make the exclusion order run for the length of time it would have taken the person who engaged in the unfair trade practice to develop it on their own or without engaging in the unfair practice. So it's not how long it took the owner of the trade secret to develop it, it's how long it would have taken an honest competitor to develop it.
Thank you.
Or semi-honest.
If I may just add one other thought, the very
Please.
case that RT was talking about where Judge Moore asked that question, that was, I believe, if not the first, certainly one of the first trade secret cases that came before the commission. And I thought that perhaps the most interesting outcome of that case was that the commission believed, and the Federal Circuit affirmed, with Judge Moore dissenting, that it doesn't matter what the activity would have been considered in this case in China. If it is viewed as trade secret misappropriation under the law that is imposed or utilized by the commission, if it constitutes trade secret misappropriation, that's good enough, even if it could be or might be that it would not be considered misappropriation under, call it, local law. And that ran, I have to say, a little bit contrary to some federal law that dealt mostly in the security field, having to do with the extraterritorial application of U.S. law. But for these past 10 or 15 years, that has continued to be the law. So if you have a situation where the misappropriation occurred entirely abroad, the commission could well be the place to go because it has no trouble applying domestic law to that misappropriation.
No, exactly. I was going to discuss that later. And there's actually some even, I guess you'd call them expansions or elaborations upon Trenri and extraterritorial.
Sinochemical.
What?
I say there was another case where it went and they tried to get rid of certiorari at the Supreme Court, and the Supreme Court turned them down. So that is certainly the law.
Yes.
I think it was Sinochemical was the second case. So.
Yeah, absolutely, absolutely. I was going to get there. So really quickly, do you mind going to the second slide, Blaney?
No.
Okay. Okay, so this is a similar slide to the one Tom showed. It's one of the official ITC statistics. It shows the number of cases per year that are solely patent infringement versus solely trademark infringement versus trade secret, and then the last two are sort of mixes. As you can see, the number of non-patent cases has really been increasing over the years. You know, if you look at trademark cases for 2014, there's one case. 2015 was definitely sort of banner year from trademarks, a bit of a statistical anomaly in that there were 7, but then there's 3, then there's 1, then there's 0, and then in 2019 there's 3, and in 2014 there's 4. So it's slowly trending up. Same for trade secrets. You know, you have 2014 is 1, 2015 is 1, but then in 2016 you have 4, and in 2020 there's 5. And the same for the sort of mixed cases as well. So there's been this real trend towards the non-patent cases. And as Tom says, you know, the docket is still mostly patents, but these things are rising. And one thing that's interesting, I've seen some statistics. I mean, Tom gave us some great statistics about overall win rates. I've seen some statistics that indicate that the win rate for complainants in non-patent cases is even higher than the general win rate for ITC complainants overall. It's not a huge amount higher, it's somewhere in the 60s, but it is significant. Of the non-patent cases, most of them are trade secret. You know, in 2019, the subject matter of the trade secrets included Botox and bone cement. There's lithium batteries, and then there's food service equipment and balanced armatures, which I believe are used in cranes or some sort of construction equipment. You know, there were also Lanham Act allegations for falsely saying that certain pieces of equipment met Energy Star requirements, and there was a copyright cases on dresses, on clothing. So it just shows you sort of the variety of types of allegations and types of subject matter that can be addressed at the ITC. Good with that. You know, I believe that this year there's actually a case pending on chocolate milk. think it's a trademark case. There's one on IVF. There's just, people can be really creative with this, and it's not just high-tech cases like people sometimes thought during the smartphone wars. Okay, so one of the things that I think is most fun about trade secret cases is that the fact patterns are really interesting. They inevitably involve something pretty entertaining. So I wanted to talk to you about a couple of them. I don't know how many of you saw this weekend. President Biden actually discussed a settlement in an ITC case this weekend, which was pretty cool. It was because it impacted electric cars. It was the certain lithium-ion batteries case. It was ITC investigation 1159. In that case, LG Energy alleged that SK Innovation had hired away some of its employees and sold their trade secrets. I believe others on this case may have more details, because one of the things that's very interesting about ITC litigation and being an ITC practitioner is that the communities are relatively small. So honestly, I think most of the cases we'll discuss today, one of us was involved in some capacity, if not multiple ones of us. But overall, it dealt with electric batteries for cars. So we're talking about increased fuel efficiency, and energy conservation, which is a big national interest. So I don't believe anyone has mentioned, the ITC considers public interest in its decisions. It is a government agency, so it does consider the effect on the public if the exclusion order goes into place. And because this case potentially or allegedly would limit the supply of electric batteries and thus limit the supply of electric cars, a lot of people watch this case as an interesting one, because public interest is not used to totally deny relief very often, but in the cases where it has, it's often because there's a strong national interest in something, like our national interest in fuel efficiency. So trade secret case, the administrative law judge found a violation and the commission agreed. So they ordered that exclusion order issue. So after an ITC exclusion order issues, there's a 60-day period for the president to essentially veto the order. The president, I believe, has delegated that responsibility to the USTR, but in any case, it's that branch of government has the opportunity to veto things. They don't do it very often at all. There was the first sort of recent case was in 2013, and I was at a talk by the guy who was responsible for it, basically, or was involved in it, and he said everyone responded like someone had unfrozen a caveman. I think the last vetoes before that were in the 1950s, 1960s. They were just a very long time ago, and people had sort of forgotten that sometimes the president actually did veto. But so anyway, you have the commission has ordered an exclusion order, potentially big impact on electric vehicles, and the USTR and the president are considering whether to veto this. And I believe this weekend was about the end of the presidential review period, and the companies announced a settlement. It was huge. It was 1.8 billion, which is just tremendous. And like I said, it was important enough that President Biden actually made a statement about how relieved he was and how happy that this was happening. So our electric vehicles could go on. I don't know if Blaney or Tom has something to add, or maybe I'll just.
Well, what was interesting about that case is that, and full disclosure, I do represent SK, not in this particular matter. But what was interesting about that case was that the actual exclusion order was based on a spoliation defense, and the exclusion order was entered without actually a trial on the merits of the trade secret violation. And there was a question There was a question on the floor about whether or not the ITC has a procedure for early detailed disclosure of the specific trade secrets asserted to be misappropriated. That's a very good question. The answer is essentially no. You know, that is one of the things that needs to come out in discovery and as part of the practice in these trade secret cases. You know, when the whole thing gets, you know, essentially shortcut because of the spoliation issue, it becomes a hard thing to deal with as a practical matter. So the case that Artie's talking about is one that you know, had a lot of pressure in it just because of the procedural posture in the ITC and the scope of the exclusion order that would have come out of it. Ted, you were going to say something about that?
Well, yes. First of all, it wasn't shortcut without a trial, but the hearing was postponed because SK, in their own words, destroyed the evidence would have been necessary to have such a hearing. Unfortunately, as has happened in several cases, including ones that were before me, this one I was simply part of, they in their own internal correspondence, admitted to destroying things and then said, and not only destroy it, but destroy this message telling you to destroy it. So it wasn't short circuit in any way, and it wasn't decided on spoliation. It was decided based on misconduct, and the misconduct included violation of the trade secrets, and misconduct included destroying evidence after this case was filed and others. So I think we ought to characterize it accurately, and that is an accurate characterization.
I don't argue with it, Judge, on that one.
Well, I think Blaine.
Well, it was
Okay.
and I know that was SK kept arguing that, you know, we didn't have a hearing. Well, the reason you didn't have a hearing is you destroyed what was necessary to have one, and so that's held against you. So it was an interesting case. I think what I would get out of it, without going into detail on what's going on, but LG chose to go there because they did not want to have their trade secrets used in a plant in the United States and then have to compete with them. So it emphasized several things. One was the speed with the ITC, that the district court average running time, I think, Tom, your slide showed average running time, if they're doing really well, is about 3 years. And here SK is proceeding with a plant that LG desperately wanted to stop, and 3 years would not have done that. They'd been, you know, running for a long time. So that really underscored where the ITC has a place here. The second fact I think really underscores the ITC has a place is these alleged thefts, the theft of the trade secrets, all, if it occurred in Korea. So again, the district courts, although they might have been able to do something with it, in this case, it was very clear the ITC could. And so they made the choices. So I think the bright line here demonstrates that for the speed, and if sometimes trying to stop your competitor from eating your market share is more important than just money damages, and you can wait on money damages. So the case very much chose the ITC, and I think demonstrated the advantages the ITC has over a district court. And now that we've all settled, we're all friends again. So it's going to be a fun time.
We're all settled. We're all friends.
I was just going to add, Blaney, I think we're 2-1 against you on this one. But to get back,
all right, I'm used to it.
To get back to the question that was asked, in terms of early disclosure of the trade secrets, early is of course relative, and because the commission timeline is so short, the answer is, I think at the ITC it would be considered relatively early disclosure because the judge is going to require a narrowing of the issues. If you go before the judge, as we have in other cases, with a couple of hundred trade secrets, the judge is going to cut those down pretty darn quickly and force the parties to focus on the ones that they can actually try within the week or so that is available. So that narrowing usually takes place 4, maybe 5 months into the case. So I'd say that you have to disclose the trade secrets that you're trying to protect under your protective order pretty darn fast.
Well, and this brings up what I consider to be one of the practicalities of practice in the ITC that really is a bit different than district court, and that is because of the timeline. You don't really need a whole lot of rules about what needs to get done in advance. You know, there are ground rules that all the ALJs have, and they're very detailed, and they help a lot. But the plain fact of the matter is, because you're under this timeline gun, so much of the time you have to do what's practical that you can prove, and what is and what you have the ability to really get the evidence for in the short timeline that you have. So yes, I understand the wanting the rule about it, that a lot of times they have it in district court, but it's in some ways, as you note, Tom, in some ways it's not really too necessary, because you got to get there pretty quickly anyway in the ITC.
Okay. Speaking of short timelines, I'm just going to try to go through the last bit really quickly.
Okay.
And going to go from one Tom case to another Tom case. Like I mentioned earlier, Tom and I had a trade secret case that ended up being argued before the Fed Circuit in 2011. It was the Tianri versus ITC case. Before the ITC, it was certain cast iron railway wheels. Like Tom said, this case got a fair amount of attention because even though I don't think it was the first trade secret case at the ITC ever, it was the first one in a very long time. So it was very interesting, and it had some interesting aspects to it in that though the plaintiff, Amstead, was, located in North America and had developed the trade secrets in North America, a lot of the things happened overseas. What happened is, Amstead makes cast iron railway wheels using, actually the ones they make and sell in the United States are made with a different process, but leaving that alone, they make and sell railway wheels. They developed a process. They went into China to do a joint venture to make railway wheels over there. And lo and behold, a couple years later, Tianri is selling railway wheels that seem awfully similar. So they sued in the ITC, and one of the initial, there were a lot of issues in this case, right? First of all, whether Chinese law should apply, whether what they did is a violation of Chinese law, whether Amstead had kept things secret, whether or not Tianri had independently developed things. But overall, and the big question was, did the ITC have jurisdiction over this? Because any alleged misappropriation happened in China. Many of the people involved were in China. The wheels were made, the allegedly infringing wheels were made in China. So it really was interesting because if the ITC was going to rule on this, it would be applying U.S. domestic trade secret law to actions abroad. What happened was the judge found a violation, the ITC agreed, and then it went before the Fed Circuit, where a lot of the discussion was about this, about to what extent is this the ITC and thus the US extending its rules extraterritorially, which it is not supposed to do. And Judge Moore who was on the panel, had interest. I'll try to be diplomatic, although I tried to be diplomatic with the past case and talking about the document destruction, and that didn't really work. But she had an interest in the broadness of the statute. And, the Fed Circuit actually said, the question here is whether Section 337 authorizes the Commission to apply domestic trade secret law to conduct that occurs in a foreign country. The Fed Circuit agreed that it did. There was a dissent from Judge Moore about the vagueness of the statute, but that decision held, and it's been elaborated on. The case that probably gets the most attention is what Judge Essex, who I still can't call Ted, discussed, which was a certain rubber resins case. It involves Sino-Legend and SI Group, which are both Chinese makers of rubber resins. SI's ITC complaint alleged that Sino-Legend poached one of their main employees, allegedly the only employee who knew the whole process from start to finish. They poached him, and shortly after the departure, Sino-Legend, lo and behold, starts manufacturing identical resins. So, of course, SI accuses Sino-Legend of using the secret processes, and also they accuse them of filing patent applications that had some misappropriated information. Before SI did file a trade secret investigation in the ITC. It appears that before they did that, they went to the Chinese courts, and it's not clear from the record, because it's sort of garbled in the ITC public versions, but they did have proceedings in China, and there were some weird things like SI may have not appeared in court, but in any case, the Chinese court decided that SI's supposed trade secrets, at least half of them were known to the public already, so they weren't trade secrets, and that they also decided that the technology Sino-Legend used to make its resins was not materially similar to the alleged trade secrets anyway. On the very same day that the Chinese court's decision came out, the ITC initial decision came out too, and that found exactly the other way. It found that SI did have trade secrets and they'd been misappropriated. There was an appeal, it went to the commission. The commission agreed that there was a violation, and they issued a 10-year exclusion order. Went to the Fed Circuit, and they affirmed, and then parties filed cert petitions to be heard by the Supreme Court. And this all would have been very interesting, because I'm not sure there actually has been an ITC decision before the Supreme Court.
Never.
Sorry? There hasn't
Nope.
been. Yeah, I didn't think there had been, but I don't know, back when. The other thing that happened that was extremely interesting is that the government of China actually submitted an amicus brief in the Supreme Court petitions, which is actually apparently the first time they've ever done it. And they basically said that the ITC should have no jurisdiction over this because this was an even further than Tianri. Tianri at least involved a North American company and some secrets developed in the United States. This case was two Chinese companies, all Chinese individuals, you know, the inventors and the people that, everything occurred in China. And then on top of that, the actions had actually been adjudicated by a Chinese court to be legal in China. They actually said, I quote, "The ITC has impugned the sovereignty of China and refused to accord the comity expected of a trade partner." So it was pretty strong language. And the Supreme Court denied the cert petition. So the reading of the statute that it can encompass actions that were totally within another country and are in fact legal in that country stands. And I have some more cases, but I think I will.
I think we'll move. We'll go from there. So really, Artie, thank you very much. I appreciate the words on this one. The next, we're going to talk a little bit about domestic industry. It's kind of one of the pieces of the statute that really distinguish it from district court. And Lei Mei, I think you've got this one.
Okay, thank you. Good afternoon, everyone. I'm going to discuss a fairly unique aspect of ITC practice, which is, like Blaney said, Section 33, domestic industry, which is one of the requirements for complainant to, complainant has burden to show domestic industry in order to prevail in a ITC investigation. But before I start, let me see, there is a question regarding what is effect of an ITC invalidation of a patent in a parallel district court proceeding. So it's actually a very good question, as I think other panel members have mentioned. ITC decision is not binding in district court. So the ITC invalidation of a patent really is not binding. That decision is not binding in district court proceeding. But practically speaking, parties often appeal that decision to the Federal Circuit. Imagine, you already have claim construction rulings from the ITC, and that being applied to prior art to find invalidity. And if the Federal Circuit upheld that invalidity ruling, then even though that decision is still not binding in district court, but in the parallel district court proceeding, the judges would be highly persuaded by Federal Circuit's ruling, not only on claim construction and also on the ultimate legal question of validity or invalidity. So I think, practically speaking, if a complainant loses the case based on patent invalidity, the question really becomes whether do you want to appeal to the Federal Circuit to let Federal Circuit to make a final determination, final decision there, not binding but highly persuasive to a district court judge, or just sort of give up at that point in terms of ITC proceeding and go back to the district court, re-argue claim construction, argue, invalidity in front of jury. So that's, I think, practically speaking, the litigants have to decide once there is a ITC invalidation of a patent, whether you want to continue appeal or, just go to the district court and litigate, the same case over again. But even when you go back to district court, we had a situation where the district court judge, adopt some of the ITC's claim construction, but not all. But that's very case specific, right? Some judges may be more persuaded by ALJ's and ITC's claim construction ruling, and some district court judges may come up with their own claim construction rulings. So that's a sort of really a practical consideration that a lot of litigants need to consider. Now let me go back to domestic industry. So domestic industry requirement really has two components. One is called the technical prong. The other one is the economic prong. The technical prong requirement refers to whether complainants' domestic industry products practice the asserted patents. Right? The standard is the same for patent infringement. That is whether complainants' domestic industry products meet each and every limitation of at least one claim of each asserted patent. So that analysis is fairly straightforward. The focus here today is the economic prong, which typically refers to whether complainants' domestic industry investments are significant or substantial enough in certain areas of business operation. So that leads us to the 2015 Federal Circuit opinion in Lilo v. ITC. Blaney, if you can pull up the slide. Okay, I don't see the slides yet. Can you guys see the slides there? Slide on the screen? Oh, I think it's coming up now.
Did you get it?
Yeah. So in this case, the Federal Circuit provided additional guidance as to how to conduct economic prong analysis. Unlike the technical prong, economic prong analysis is fairly complicated. It's contextual based, fact specific. In the underlying investigation, the ALJ initially found the domestic industry investments were modest in the Lilo case. And as a result, the ALJ found no domestic industry and thus no violation of Section 237. On the commission review, which is a sort of internal appeal process within ITC, the commission actually found, even though the domestic industry investments were modest, but qualitatively, the investments were directed to components that were critical to domestic industry products. So as a result, the commission found a domestic industry. And Lilo, responding in that case, appealed to the Federal Circuit. The Federal Circuit there provided additional framework as to economic prong analysis. So the Federal Circuit said qualitative factors alone are insufficient to show significant domestic industry investments. And the Federal Circuit further held that qualitative factors cannot compensate for quantitative data that indicate insignificant investment and employment. So this is really a tension between quality versus quantity, right? So what are the qualitative factors? Typically, those factors could be evidence to show that domestic industry investments are critical to making or technical support or maintenance program for domestic industry products. Then what are the quantitative data? Those typically are the the dollar amounts, right? How much domestic industry investments in the plant and equipment, labor, capital, R&D, for example. So traditionally, parties present actual quantification of domestic industry investments in dollar amounts, and the question would become, how once you have the data, but how do you quantify them in a way to prove or disprove whether those investments are significant or substantial? So let's go to the next slide. So traditionally, it is the analysis is context-based. The ALJs will make initial determination based on domestic industry data and in the context of the marketplace, including the size of the company and the industry in general. Like for example, like $100,000 domestic industry investment may be sufficient for a small company, right? But that may not be sufficient, may not be significant or substantial for a large company, large multinational company. So significance is very contextual based. So in 2019, in the 1123 investigation, the commission provided some examples as to how to quantify domestic industry investments. For full disclosure, our firm represented a respondent in this case. We were happy with the outcome, and even happier, we have the the commission actually provided some concrete examples as to how quantification of investment, domestic industry investment may work. So here, the commission found investments insignificant and insubstantial when considered in light of the only contextual information in the record, that is complaint U.S. sales and worldwide sales of domestic industry carburetors. Let's go to the next slide. So here the commission cited two charts, right? The first chart, which is the percentage of U.S. investments compared to U.S. sales. The second one is percentage of U.S. investments compared to worldwide sales. So as you can see, the exact percentages were redacted. That actually underscores challenges for litigants to conduct legal research, right, as to what percentage may be sufficient. And keeping in mind, the economic prong analysis is based on totality of circumstances, right? Totality of facts based on specific market conditions that may include, respondent size and industry in general in that particular case. So the percentages here, even if we know those percentages in a public version, those only, can only be one indicator. And the commission still looking into many other indicators, but this percentage could be a very powerful indicator. And like I mentioned earlier, unfortunately, those the sales information, including the percentages, are confidential business information. Generally, they don't public version of commission opinions or ALJ's initial determinations. And so a lot of practitioners really have to make educated guess based on their experience. So in our experience, later on I'll open this up for my fellow speakers to opine on how quantification may work. But in our experience, if the percentage of U.S. investments compared to the U.S. sales is more than 10%, and still you have to analyzing other facts, right, other indicators. But if that's the percentage is over 10%, and that creates a strong argument that there might be a domestic industry, that domestic industry investments are significant or substantial. And conversely, if the percentage is less than 5%, then I think there is a credible argument for respondents to attack domestic industry, the domestic industry argument presented by complainants. So again, I mean, this type of percentages are just one particular factor, one particular indicator. Commission and ALJs are looking at multiple factors involved. One more thought here, in terms of percentage of U.S. investments compared to U.S. investments compared to U.S. sales, that's actually fairly common in an ITC investigation where parties present that data. But the second percentage, which is compared to worldwide sales, is not as common, but certainly it's also another indicator for the commission to determine. And so that's pretty much, I think, a very short presentation. Domestic industry,
thank you,
economic
Layman. I really appreciate that. And it's a common topic and a difficult one in terms of being able to practically know where you are on the domestic industry, unless you've got, unless you're in one of the large, either on one side of the spectrum where you've got lots of domestic industry, or on another spot where you don't have one. It's hard really to cut the baby. Right now, we're gonna. I think one of the topics that we want to go to, or that really goes back to the whole idea of injunctive relief, are standard essential patents, and I'm still going to call Ted. So we have Judge Essex, who's going to talk a little bit about standard essential patents, because he's kept up with this and has his own personal interest in it, and it was really interesting to talk with him earlier about that. So I hope he gives us a little entertainment on that particular topic, because the interaction with the ITC is certainly one of the more important, what I would consider aspects of patent litigation in worldwide at this point.
All right. Thank you very much, Blaney, and you're welcome to call me Ted. All of you are, as far as I'm concerned. Since I retired from the bench, I'm back with you all, and I also would invite Artie, Tom, and Lay, if you have something to add, I'm sure you do, then please jump in with me. I won't take any offense at all, and I very seldom bite anybody anymore. But let's clear up what you said about standard essential patents, because as general rule, there's no such a thing till after some court has declared it. Every standard setting organization whose bylaws and such I've read has told people that if they have a patent that might read upon a particular standard, they should declare it. Now, the if and might make it possible. It might be standard essential, but no standard setting organization I'm aware of, and no company goes back and tests and just stamps it or puts a little gold seal on it and says these are standard essential patents. So they are patents that potentially could read on the patent and standard rather, and that's important as we get later on the discussion. Because of most organizations that are standard setting will request that the parties will sign a pledge, kind of like having a bunch of alcoholics pledging not to drink, that they will only charge a fair, reasonable, and non-discriminatory rate for licensing their patent, or give it away free. They're allowed to not charge. In the genius of business practices, none of these organizations have defined what fair, reasonable, non-discriminatory is. Some of them have actually tried to put in provisions that allowed them to go to binding arbitration and so on. I'm thinking of Etsy in particular. And the members removed that. They did not want to be forced to do the reasonable thing, rather like my ex-wife. But that's neither here nor there, really. So that brings us to the ITC, and the argument has been put forth by a number of academics who must publish or perish, and I think they picked the wrong option. They have said that since they have agreed, which isn't exactly true, that they will only charge a friend rate, which isn't what the agreements say, they shouldn't be allowed to have an exclusion order, which isn't written anywhere. But so they like to say. And so they said the ITC should not review these patents and should not grant any exclusion orders. The ITC has had a number of cases that are involved with theoretically standard essential patents. And the one famous case, there's one case where they actually found that there was a FRAND defense. That was Apple and Samsung. The trick there was the parties didn't challenge that or didn't try to prove it, but they seemed to agree that these were standard essential patents. And so the ITC did in fact issue an exclusion order, and the U.S. Trade Representative overruled that and did not allow that to take place. The precise reasoning was never clear. If you read what they said, it was honestly to defend the commission. They said the commission should consider these things in certain ways, which, as far as I could tell, the commission had indeed considered those things, but it was Apple. So I don't know precisely if that totally explains it, but I think it goes a long way to explain that. Since we've had that case, there have been about 16 different cases that have hit the ITC. Some of them settled, Erickson versus Samsung, and I believe the 863 case in that. Some of them were decided by learned judges, mostly Judge Shaw. Occasionally, I took a swing at some of these things. And we found some very interesting things out in reviewing the cases. And the first one that we found out is that parties were suggesting we should not, the ITC rather, should not have the right to consider an exclusion order because there is a FRAND commitment and so on. And now, as a judge, having taken absolutely no evidence, how they could make that argument always confused me, because it's sort of, these are standard essential. Who says so? Nobody. And nobody, in fact, did say so. So my first point was, the statute said if you have these certain circumstances that the ITC will do an investigation. Well, to do an investigation, you have to have a hearing. At least that's the way we've set it up. And to have that hearing, you have to hear evidence. And what has been remarkable, if you look at the cases that have followed the Apple Samsung cases, I have found the fact that there has not been another case where they found that the patent was in fact standard essential. That has never been determined. And in fact, neither side, complainant or respondent, we'll leave out OUI for right this time, but neither side seems to put in any evidence regarding the standard essential nature of a patent.
Judge, can I stop you for just 1 second and ask you a question about that?
You just did, yeah.
Well, is it the case that essential in fact and standard essential in terms of the FRAND obligation that's been made for a standard setting organization are two different things in terms of your consideration of these issues?
Well, let me back you off of that. For the first thing is, we're supposed to determine all the facts about a patent, which is validity, infringement, and so forth. Nowhere in there is there anything in the statute 1337 that suggests that it's relevant whether or not something may or may not read on a standard or what a standard is. So they're kind of bringing things in and saying, well, if it is standard essential and it's, infringement, valid, and so forth, then you can't do an exclusion order. Well, that statute doesn't say a word of that. And what I have found, your question would be interesting if it was ever raised, but if you go through the cases where there was a potentially patent that read on a standard, we have not had evidence presented in any of the ones that I can find out. There may have been some in the Ericsson Samsung case, but because that's settled, it's hard to tell what was presented and so on. But what we have found is I think complainants do not want to assert their patents are standard essential because that might leave open a gate under public interest factors or just what have you for the respondents to claim an exclusion order is inappropriate. So complainants have no motive to try to establish the patent is standard essential. There's nothing to be gained for them that I can figure out. Smarter heads might prevail. Tom, I'm looking at you when I say smarter heads might prevail. But respondents, while they would like to perhaps assert there cannot be an exclusion order, in order to say that's because it's a standard essential patent, they must admit validity and they must admit infringement. And right now, of the cases, frankly, the respondents are doing very, very well in these cases. And most of them, since the Apple case, have been found on either non-infringement, in which case the patent perhaps is not standard essential, obviously, but there's never been evidence presented on standard essential. And the respondents are doing very well on either validity or non-infringement. There was one case where they tried to assert something, I think it's up line Blaney with what you were saying, a de facto standard. That was Cisco and Arifa 944. Right. And the commission just they just rejected that as, I'm not sure they knew what it was, and they just rejected it. But in case after case, they have found some patents were valid and not infringed. Some were not valid, but none of them have been found to read on a standard, and there's been no evidence that I can tell that presented that these were in fact standard essential patents or that was relevant. But again, I think this is not a problem because I don't think that you can assert at the beginning of an ITC case that you could not get an exclusion order because these are standard essential patents, because unless you were willing to admit validity and infringement and so forth, you don't get to that point. And when you start in there and gather up the evidence, the parties are not presenting evidence on the standard essential nature of them for the reasons I've outlined. At least I think those are the reasons. And those of you that practice, if you're a respondent, you don't want to admit it's valid and infringed, do you? And if you're a complainant, you don't want to go down the road that, yes, I do admit that money's enough and that. So it doesn't come up. At least they don't present the evidence. There are a number of places and a number of government agencies, and the FTC was one that suggested if it's a standard essential patent, then we should change the rules of evidence. And the commission, the chairman of that commission is now my law firm, so I can't browbeat her too badly. But
you, Chairman,
he said the burden.
Sorry to interrupt. They revised their guidance. They
did. You're absolutely right. And I like to think it's because I did beat her up, in my opinion, but probably not. But yes, they did revise it because their guidance it wasn't panning out. And anytime that I saw that you had patent owners that were engaging in patent holdup, there's maybe somebody did, but there was never any evidence of that at the ITC. No one ever put in that evidence. And there was plenty of evidence that people that were implementers would use the technology that may or may not have been the standard central patent infringed, because no one determines, again, whether it's a standard central patent. That's never a determination is reached. So whether these are standard central patents, whether there's a FRAND duty, and there's more to a FRAND duty than just saying it. So we never got to those points, and we never got the respondents to press them on that, and we never got the complainants to say this is standard central, so money's fine. So I think it's a non-starter in the ITC.
And I think that's the essential point, is that in these worldwide patent litigation disputes, the Ericssons, the folks who are going and enforcing portfolios across the world, the respondents are going to have their shot in the ITC, and the ITC is going to be a valid forum for these disputes, because there's not going to be a rejection of the exclusion order in the ITC, or at least there hasn't been, and doesn't seem like there's a reason, especially with the analysis that you just did, that there ever would be.
No, I had a list of about 16 different cases, and in all the other cases, they either found the patent invalid or non-infringed. So it looks like there has been no problem with the ITC holding a hearing, gathering evidence, and then weighing that evidence. And again, we don't know how many of the so-called patents that have been registered as reading on a standard that actually do. There's some anecdotal evidence that doesn't happen very often, that oftentimes these patents certainly don't. So, Adam, I see you up there. Is that time? Do you have an announcement, or did you just want to be on stage?
Maybe, why are those things mutually exclusive? No, it is. Unfortunately, that we have hit the time. Yeah.
Well, Adam, in fairness to Blaney, he was the one speaker who hasn't gotten a chance to speak. Maybe 5 minutes on IPRs, Blaney?
I'll make this very quick.
Okay.
The first point about IPRs in the ITC is that the ITC procedural schedule is not going to be stayed because of an IPR. I think we're all pretty familiar with that history. The second point of the IPR ITC interaction is that there's this doctrine out there called the Fintiv factors, in which the PTO is just using its discretion under the IPR statute to deny institution of IPRs in situations where you have a parallel district court case going on along with an ITC case, and the IPR gets brought in that situation, and since about September, about 20, at least by my count, about 20 IPRs have been denied institution because of that. So there is a serious interaction between, and it's discretionary at this point, so it might get changed, might not. There's a serious interaction between the various ecospheres that we've been talking about, PTAB, District Court, ITC, and they are arranging what they consider and then what they don't consider, at least in part based on what is going on in other forums. So it's important to understand that, and you can follow the arc of cases that fall out of the Fintiv matter to help you on that. The only other thing that I will say about the IPRs is that they are definitely having an impact in district court cases, and people are working their ITC strategy around the effects of both whatever might happen in district court along with the PTAB. So I know I've used enough time on that, and I just wanted to get those points out there. Thank you very much. And, guys, it's been a really It's been a treat to be on a panel with you. I think you've all been wonderful. I hope that the audience has enjoyed the interaction. And Adam, I'll turn it back over to you.
Sounds good. Echoing everything Blaney said, thank you all for participating. It was very insightful, and glad to get the ITC perspective, which I think already commented that sometimes it goes overlooked in these conversations. So thank you all. What we're going to be doing now is we are going to be transitioning to a short break, a little shorter than 15 minutes, but for good reason. We will be back up here at 1:45 Central Time. So see you on the floor. Thanks again.
Thank you.
Thank you.
Thank you.